May prevent. I have filed one MSc appeal. There is some urgency. Can it be taken up on Monday?
Fresh filing.
Fresh filing.
Okay.
Apply.
May I please your lordship? Your lordship, I beg for listing of two MSc appeal for in order column. Thanks. Hello.
May it please your lordship. Lordship, I beg to mention for listing of one RFA, lordship, for orders. And the date may be given.
Pending.
Obliged.
May please the lordship. So I am paying for listing in IA. I filed this IA for modification of the order.
Pending for
Please, your lordship. Also praying for listing of IA for withdrawal of 50% of the award on Monday, lordship.
Okay.
Other lordship.
May I please, lordship. Lordship, I beg to mention a IA for condonation of delay, lordship. Kindly listed it.
29.
May I please, your lordship. Lordship, I beg to mention item number 3. Due to personal difficulties, yes, lordship, senior counsel could not come. May time I fix for next week.
What is your name?
B. Doctor.
Heard Miss B. Datta, learned counsel for the appellant, who prays for an adjournment due to personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed. 3rd of August.
Obliged.
May I please your lordship? Your lordship, I beg to mention item number 26, 27 and 29.
Yes.
Your lordship may be listed after 1 month. Just yesterday I have taken steps.
Heard Mr. D. Mandal, learned counsel for the appellant, who submits that he has taken steps for issuance of notice upon the respondent yesterday only, and therefore prays for listing this appeal after 4 weeks. The prayer is allowed list accordingly. Separate order, separate orders, similar order. Yes.
Lordship, 3rd of September.
List on 3rd of September. Yes.
Highly
May it
obliged.
please your lordship, I beg to mention item number.
In September, 2nd September.
May it please your lordship, I beg to mention item number 4. Kindly adjourn the matter for 3 weeks. The name of the respondent has not been shown in the cause list.
Respondent has appeared.
No, lordship, no name has been shown.
Now, whether a respondent has appeared or not.
I was not in this case, lordship.
Heard Miss D. Goswami, learned counsel for the learned counsel, submitting on behalf of Mr. R. Goswami, who prays for an adjournment due to personal difficulty of the conducting counsel for the appellant. The prayer is allowed. Let this matter be listed after 3 weeks on a date to be fixed by registry.
Lordship. Obliged, lordship.
May payment.
Yes.
Item number 10. Can it be taken up any other day?
Heard Mr. A. Bhattacharya, learned counsel for the appellant, who prays for an adjournment on the ground of personal difficulty. The prayer is allowed. Let this matter be listed. 7th of August.
Apply.
Lordship, I beg to list the matter for MCT appeal for orders.
29 July.
May I please, your lordship? Lordship, I beg to mention for listing of a first appeal, Lord, on 29th of this month.
At which column?
For orders column, ma'am.
29th. Okay.
Much obliged.
Item 11.
Yeah, pleasure, lordship. Lordship, my senior is Lexi another call. Lordship, may kindly pass over the matter for time being.
Can it be taken up at 12?
12. Okay, at 12.
Orders, item 12.
Where please, Your Lordship. Lordship, AD card has been received.
What is your name?
AA Ahmed.
Heard Mr. A. Ahmad,
On behalf of Mr. R. Hussain.
appearing on behalf of Mr. R. Hussain, the learned counsel for the appellant. On perusal of the office note dated 15/7/2026, it appears that the AD card sent along with the notice issued to respondent number 2 has returned with signatures of the addressee thereon. So in view of above, the notice issued to respondent number 2 is held to be duly served. And what happened to respondent number 1?
Number 1 has appeared, but today they have not. The Union of India.
Records I see. Since the records of the trial court have already been received, this matter is ready for hearing. Accordingly, list this for hearing after 4 weeks on a date to be fixed by registry.
Obliged.
Item 30. Item 30.
None has appeared for the appellant on call. 1-3.
Yes, yes, ma'am. My lord, this matter, my lord, we are handed over all the briefs to the company, my lord. So now we are not in this case, my lord. So our name may be deleted, my senior's name and my name, my lord.
You have to give some letter while handing over the brief back to the company. You have addressed them some forwarding letter. The correspondence by which you have handed over the brief back to the company, a copy of that correspondence you have
I
to
will bring, my lord.
produce. Heard Ms. L. Sharma, learned counsel for the appellant, who submits that she and her senior, Mr. S.S. Sharma, have returned back the brief to the appellant insurance company and seek some time to submit proof thereof on the next date fixed. The prayer is allowed. Let this matter be listed after a week on a date to be fixed by registry.
Item number 14, my lord, this is also my senior's brief, my lord. And brief is misplaced, so my lord, some time may be needed to take steps
Item number 14.
on respond number 6 and 7, I think, my lord.
14 and 15.
14.
and I am appearing for Oriental Lordship. In 14, I am appearing for respondent 6 and in 15, respondent 3. 14 is filed by insurance company, 15 is filed by claimant. Lordship.
Separate order. 14 not likhable. Heard Ms. L. Sharma, learned counsel for the appellant. Also heard Ms. R.D. Majumdar, learned counsel for respondent number 6. Learned counsel for the appellant has submitted that she has misplaced the brief of this case and therefore seek some time to trace it out. And you have taken steps or not?
No, my lord.
And
Only
then,
6 and 7, I think, my lord. 6 up, I guess.
and thereafter
5 and 7.
may be allowed to take fresh steps against the for issuance of notice against remaining respondents, namely respondent number 4 and 7.
6 is the
Six
appearing,
I'm
my
appearing.
lord.
6, 4 and 7.
Yes, ma'am.
The prayer is allowed. Let this matter be listed
After 4 weeks, my lord.
My name, Lordship, is not shown.
after 4 weeks. Name of Ms. Adi Majumdar may be reflected as counsel for respondent number 6 in the cause list henceforth.
Hello, then.
Oh, bless you, my lord.
And in next item number 4,
15 appellant is different, Lordship. We are respondent.
15, the none has appeared on call for the appellant. Miss R.D. Majumdar, the learned counsel for respondent number,
Respondent number 6, Lordship.
respondent number 6 and Miss
No, 3, Lordship, in this 3.
respondent number 3 and Miss,
No, they,
Party, my lord, in this.
they are not party.
I think not, my. No.
You are for United.
Yes, my lord.
You are respondent number 6.
Okay, my lord.
No. Let me see the memo.
Here also my name is not shown. Yes, because हम लोग को नहीं दिया. You have received. एक बार you brought the pen.
Respondent number 6. Also, Miss L. Sharma, appearing for respondent number 6, is also present. Let this matter be listed after 4 weeks along with MEC appeal number 381. No.
446 of 2008.
446 of 2018 after 4 weeks. Name of Miss R.D. Majumdar may be reflected in the cause list as engaged counsel for respondent number 3 henceforth.
Hello, like that's
See,
Lordship. In this case, actually it was already fixed for hearing, so it will go for hearing, Lordship. And my name is also not showing in the cause list.
You are for?
I'm for appellant, Lordship.
Heard Miss R.D. Majumdar, learned counsel for the appellant.
LCR also received.
It appears that this case is ready for hearing. Hence, let this matter be listed for hearing on 13th of October. Name of Miss Adi Majumdar shall be reflected in the cause list as engaged counsel for the appellant henceforth.
Hello, like
item 17.
I am paying 2 days time for taking stay of respondent number 6. 1 to 5, my learning friends.
Heard Mr. K.K. Bhatta, learned counsel for the appellant. Also heard Mr. U.J. Soikia, appearing for respondent number 1 to 5. Learned counsel for the appellant submits that due to some difficulty, he could not take steps for issuance of notice on respondent number 6 as was directed by this court. Hence, he prays for some more time to take necessary steps. Prayer is allowed. The appellant shall take fresh steps for issuance of notice upon respondent number 6 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 19th of August.
Item 18.
Lordship, kindly see the last office note, Lordship, 15/7. Lordship, we will rectify the defect of steps, Lordship.
So, heard Mr. A.T. Sarkar, learned counsel for the appellant. On perusal of the office note dated 15/7/26, it appears that though the appellant has taken steps for issuance of notice on respondent number 1 and 3, however, same were insufficiently stamped and hence could not be dispatched. The learned counsel for the appellant submits that some time may be granted so that the defect may be rectified. The prayer is allowed. Also heard Mr. K. Bhatto appearing for respondent number 3. Let this matter be listed again after 4 weeks.
Lordship, registry may be directed to reflect my name in the cause list.
After 4 weeks, the name of Mr. A.T. Sarkar may be reflected in the cause list as engaged counsel for the appellant henceforth.
Item 19.
May it please the Lordship. Lordship, some time may be granted for filing of affidavit regarding justice service, Lordship.
Heard Ms. M. Soikya, learned counsel for the applicant, who seeks some time to file the affidavit in compliance regarding taking of steps on the respondents by the mood. The prayer is allowed. Let this matter be listed again on 19th of August.
Obliged, Lordship.
Item 20.
Please, your Lordship. Lordship, as per office note dated 14/7/26, answer of notice has been received in respect of respondent number 2. Postal name incomplete address.
What should you do? Incomplete address. What is to be done now? What is your submission? Address incomplete. You find out proper address. Heard Miss P. Hujuri, learned counsel for the applicant. It appears on perusal of office note dated 14/7/2026 that notice issued to respondent number 2 has returned with postal remarks within inverted comma incomplete address. Stop. Learned counsel for the applicant, not applicant, appellant, Agato appellant. Appellant prays for some time so that proper address of respondent number 2 may be traced out. The prayer is allowed. The registry is directed to place the who is respondent number 1?
Who is the owner?
Against the owner, you have not taken steps. You have taken or not?
Taken, Lordship.
Registry is directed to place the postal track consignment report of notice issued to respondent number 1 on the next date fix. List this matter again. 21 August.
Published.
Item 21.
May I have your lordship? Lordship, kindly adjourn the matter for the day, lordship. We have some difficulties in the matter. So,
Heard, Mr. What
Yes.
is S.H. Mahmood,
yes, Islam.
S. Islam, learned counsel for the petitioner, also heard Mr. Sheikh Abdullah appearing for the respondent side. Learned counsel for the petitioners has prayed for an adjournment due to some personal difficulty. The prayer is allowed. Let this matter be listed.
This matter may kindly fixed for admission, lordship. Lordship, today I appearing for first time, lordship. This matter, lordship. 7.
After 15. 21 August.
Much.
May I please, lordship, my lord.
Yes.
So this case, my lord, 602 days, my lord.
602 days.
My lord. Okay, my lord, after my lord passing the judgment, my lord.
Notice is he served?
Yes, my lord. Already, my lord, respondent number 1, my lord, has filed objection also, my lord, written objection.
Yes. What is your submission?
My lord, my lord, judgment was passed on, my lord, 29/2022, my lord. And thereafter, my lord, the petitioner, my lord, used to stay, my lord, left the state of Assam due to, my lord, financial problems, my lord, left the Assam and used to live in Lucknow, my lord, Lucknow, in Uttar Pradesh, my lord, and used to collect some scrapped materials and sold out them, my lord. And thereby, my lord, somehow they were living there, my lord. At that moment, thereafter, my lord, they were informed by the learned counsel in the tribunal, my lord, that some amount has come to the learned tribunal and they have received the check amount also. And thereafter, the very, my lord, low amount, my lord. Thereafter, my lord, they again, my lord, went to, my lord, Lucknow. And thereafter, at Lucknow, my lord, they used to talk with some advocates in Uttar Pradesh, my lord. And thereafter, they advised them to file appeal, my lord. And thereafter, they again came to Assam, my lord. And accordingly, my lord, from the date of knowledge, my lord, the only, my lord,
Where is
1/7/2023, my lord, came to know, my lord. I have stated, my lord, in para, my lord, 6, 7, 8, 9, and 10, my lord. Elaborate, my lord, I have discussed, my lord.
on what ground you are seeking? You have filed the appeal.
For enhancement, my lord.
On what ground?
My lord, on my lord, some medical vouchers, my lord, has not been taken into account, my lord, has not been considered, my lord, without showing any reason, my lord. And even, my lord, the petitioner sustained, my lord, multiple grievous injuries, my lord, but the amount as, my lord, awarded, it is very low amount, my lord.
How much?
My lord,
9,35,000 we have, at page 24.
Where is the reason for delay?
but I have stated, my lord, in para 6, 7, 8, 9, and 10, my lord. Elaborate it. Only, my lord, 602 days, my lord.
It
600.
is not only, it is a
My lord,
huge delay.
my lord, they were, my lord, laymen, my lord. They used to.
So laymen may come after 6 years also. If you take that plea that they were laymen, instead of 602 days, you could have come after 6
But
years.
after they have received the, my lord, check on, my lord. After receipt of the check, my lord, they went to, my lord, Lucknow, my lord.
When you
And there-
received the check?
my lord, on the 12/6/2023, my lord. From the receipt of the check, my lord, that is, my lord, at around, my lord, 1 year, my lord. 12/6/2023, we received the check, my lord.
Thereafter, why there was delay?
There, my lord, they came back to, my lord, Lucknow, my lord, and thereafter at that, at Lucknow, my lord, they discussed with some lawyers, my lord. They advised, my lord, and thereafter came back to Assam, my lord. That's why some, my lord, delay, my lord.
Yes,
Based
Mr.
from the date, my lord, knowledge, there is not much, my lord.
Even
Are you conceding?
we have filed a written objection also because the fact is that also immediately after passing the award, we have satisfied the award. And they have received the average amount long back in 2023. This I has been filed also in September 2024. Even after also receiving the money more than 1 year, 3 months. Also.
That is, my lord.
So that lawsuit delay, they have not explained specifically why lawsuit this delay was caused, even after receiving the money. That's assuming that lawsuit, they were layman lawsuit, but they have received the money first. Then already they have engaged their counsel at Guwahati. So all this explanation also made in that they went Lucknow lawsuit for their livelihood. All our lawsuit concocted their story lawsuit only to misappropriate all lawsuit for illegal gain by filing this application. You know, so this
No,
application
that is
is
not
not
a-
a method lawsuit. It should be
That is not
method of
illegal,
import court
not
also.
illegal gain, my lord. That is the, my lord,
And
rightful, my lord, lawful.
judgment has been passed lawsuit. Considering the hard income and all, 9,35,000 has been given. So there is nothing.
No, we have to consider whether the cause shown is sufficient or not.
Because had it been lawsuit that they did not even know about the award pass or they did not receive the money, that was different issue. They have received.
Yeah, after,
Heard Mr. S. Islam,
yes, Ahmed, my lord.
sorry, S. Ahmed, learned counsel for the applicant. This application also Mr. J. Kolita, learned counsel for the insurance company. This application under Section 5 of the Limitation Act 1963 has been filed by the applicants / claimants under Section 5, claimants for condonation of delay of 602 days in preferring the connected appeal against connected MAC appeal, wherein the judgment and award dated 29/2022 passed in MSC case number 284/2020 by the Motor Accident Claims Tribunal, Barpeta, has been impugned. The learned counsel for the applicants has submitted that the impugned judgment and award was passed. Impugned judgment and award by which a compensation amount of rupees 9 lakh, how much?
35,000.
9,35,000 along with an
9% interest.
interest at the rate of 9% was granted to the present applicant, was passed on 29/2022. He submits that as such, the appeal, he submits that the applicants are agreed with the quantum of compensation awarded to them, and the appeal ought to have been filed latest by 18/12/2022. However, same has been filed only on 9/9/2024, causing a delay of 602 days in filing the said appeal. He submits that the reason for delay in filing the connected appeal is was beyond the control of the present applicants, as the applicants used to reside at Lucknow in Uttar Pradesh for earning their livelihood. He submits that the applicants came to know about the impugned judgment and award for the first time only on 9/6/2023. And on 12/6/2023, they received the awarded amount from the tribunal. Learned counsel for the applicant submits that after receiving the awarded amount, the applicants returned back to Lucknow for earning their livelihood. And it is only in Lucknow that when they consulted some lawyers, it came to the applicants came to know that they can file an appeal praying for enhancement of the awarded amount. And as such, in the month of December 2023, they engaged a counsel to prefer an appeal. It is further submitted by learned counsel for the applicant that the engaged counsel took some time for preparing the memo of appeal as well as the interlocutory application. As such, delay of 602 days has been caused in preferring the connected appeal. He submits that the cause for delay in preferring the connected appeal has been explained in detail in paragraph number 6 to 15 of the instant interlocutory application, and same may be regarded as sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. As such, he prays for condoning the aforesaid delay and allowing the prayer for allowing the instant interlocutory application. On the other hand, Mr. J. Kalita has vehemently opposed the prayer of the Mr. J. Kalita, learned counsel for the insurance company, has vehemently opposed the prayer for condoning the delay of 630 days. আগত কৰবাত 602 কৈছো 630 how what is the delay?
As per my lord, my office, my lord, I have not gone through the.
No, 602. Delay of 602 days in preferring the connected appeal. He submits that the awarded amount has already been disbursed to the present applicants way back on 12/6/2023, and even after the receipt of the awarded compensation amount, the appeal has been filed after a period of 1 year, 3 months therefrom, and said 1 year, 3 months, the delay of said 1 year, 3 months have not been properly explained by the applicant. He submits that the delay caused in preferring the connected appeal in this case is a huge delay of 602 days, which has not been properly explained by the applicants. As such, he prays for dismissing the instant interlocutory application by dismissing the instant interlocutory application. Stop. I have considered I will go through the grounds. I will go through your petition and dictate the judgment order in chamber. There is unlikelihood that you may get relief, but still I will go through. There is likelihood of this interlocutory application being dismissed, but I will go through in detail.
There's one thing I would like to.
Yes, you may submit.
One thing, my lord, there's only the income of the, my lord, DCC has already taken 6,000 only, my lord. The notional income, only 6,000. That is also on of the ground, my lord. That otherwise the victims of, my lord, motor accident, my lord, even on the part of fault on the part of the, my lord, applicant, my lord. Otherwise, my lord, as the 6,000 only notional income. My lord, that's why, my lord, otherwise the victims of motor accident may be, my lord, suffered, my lord. That's why, my lord, that's one may kindly, my lord, consider, my lord.
How much it should have been?
My lord, should be, my lord, only 10,256, my lord. As per, my lord, minimum wages act also, even also. Otherwise, my lord, they will suffer huge loss, my lord. Only 6,000.
I'll go through your petition. Your petition is a long petition. I'll go through the grounds.
My lord.
Today itself, I will dispose it.
My lord. Obliged, my lord.
Item 23.
Lordship, office note dated 14/7 reveals that the TCR has not yet been received.
Heard, Mr. What is your name?
SK Gupta.
Heard, Mr. SK Gupta, the learned counsel for the appellant. Also heard Mr. T.R. Gogoi,
Lordship.
learned government counsel, appearing for respondent number
2 and 3, Lordship.
Two
No,
and-
sorry, Lordship. 3 and 4, Lordship.
3 and 4,
Lordship.
as well as Mr. What is
A. Borwa on behalf of Mr. C. Borwa for respondent number 1.
A. Borwa, appearing on behalf of Mr.
C. Borwa.
C. Borwa for respondent number 1. On perusal of the office note dated 14/7/2026, it appears that the records of the trial court have not yet been received. Stop. Hence, issue reminder for the same. Let this matter be listed after 4 weeks. August second week of the third week. Let this matter be listed on 30 for us.
Item 24.
Lordship, as per which note dated 15/7, LCR has come, Lordship, but instead of taking steps by speed post, we have taken steps by usual process, and that is not sent as there is no order. So may I pray, Lordship, that usual process step may be sent from the registry?
And speed post also you take because it was directed.
Yes, Lordship, yes.
Heard Mr. A.J. Sakya, learned counsel for the appellant, also heard Mr.
S.K. Gupta for respondent number.
S.K. Gupta appearing for respondent number 1. On perusal of the office note, it appears that the appellant has not taken steps for issuance of notice upon the respondents by speed post as was directed by this court. Rather, they have taken steps for issuance of notice by usual mode. The steps taken by usual mode may be sent. The notices taken by notices upon the respondent may also be sent to them by usual process. Additionally, the appellant is also directed to take fresh steps for issuance of notice upon remaining respondents by speed post within 7 days from the date of this order, returnable on 24th August.
Item 25.
May it please your lordship. Lordship, office note dated 5/7/26 says R1 has appeared, lordship. For lordship, 2-3 process server could not be served because notices were received late. But lordship, again it is said that AD for R2 and 3 not received, but we had taken step by speed post, lordship. So registry will give the
Speed post?
yes,
Okay.
and
Heard,
LCR received.
heard Miss R.D. Majumdar, learned counsel for the appellant. Also heard Mr. R. Goswami appearing for respondent number 1. On perusal of the office note dated 15/7/2026, it appears that service report in respect of notices issued to respondent number 2 and 3 have not been received. Stop. The registry is directed to place the postal track consignment report of notices issued to aforesaid respondents by speed post before this court on the next date fixed. Let this matter be listed 10th of August.
Highly of
Item 28.
28. May it pleases your lordship. Lordship, in this case, what happened? We made some typographical mistake in the memo of appeal. We are going to file a petition for amendment, lordship. So let this case come next week, lordship.
Heard Ms. R.D. Majumdar, learned counsel for the appellant, who submits that some typographical error in the memo of appeal has been noticed by the appellant, which may require filing of an amendment application, and as such, she submits that some time may be granted to them. Accordingly, let this matter be listed
Next week, lordship,
in
because we
the
have urgency.
24th of August, 24th of July.
Highly of
RP.
May it please your lordship, with respect to respondent number 3, service has been completed, lordship. Learned counsel is appearing before your lordship.
Other respondents?
Lordship, with respect to respondent number 1 and 2, lordship, the unserved notice
has come back, Lordship. So, Lordship had permitted us to ascertain the correct address, Lordship. Till date, we are unable to do so, Lordship. I'm praying for some more time to.
Heard Mr. H.R. Das, learned counsel for the applicant. Also heard Mr. K.K. Bhatto, learned counsel for respondent number 3. Learned counsel for the applicant submits that some more time may be granted to the applicant to find out correct address of respondent number 1 and 2, as till date they are unable to trace it out. The prayer is allowed. Let this matter be listed 17th of August.
Item 41.
None has appeared for the applicant. If you register Hussein applicant on call, let this matter be listed in the next week. After a week, on a date to be fixed by registry.
Item 42.
Please, Your Lordship. This connected appeal is pending, my lord. Connected appeal has been filed by this present applicant of the SAI seeking enhancement, my lord. Now, what has happened in this SAI, my lord, I have been compelled to file, my lord. In the original award, my lord, there was a direction, total awarded amount was 8,72,000, out of which, my lord, 3 minors were for 2 lakhs each, my lord, as directed to be deposited for a period of 5 years, 10 years, and 12 years. Accordingly, that amount has been fixed. Now, after expiration of that 5 years, with regards to one of the children, one of the daughter, my lord, Minu Kumari, she has recently got married also, my lord. When she went to the bank to withdraw that amount, my lord, bank has informed her that, my lord, that after expiry of that 5 years, my lord, bank has renewed of its own, my lord. Now, my lord, bank is insisting that you bring some order from the court to release that amount, my lord. So that's a simple my lord. I felt appeal is already pending, my lord. So it is not complete, my lord.
Appeal is 668.
My lord, I'm only seeking this application permission to withdraw with regard to Minu Kumari, my lord. With regard to her, my lord.
Any objection?
Lordship, in this case, actually, Lordship, the copy is not received by me. And in fact, Lordship, my name is also not shown. Today, I have somehow I found that this case it may belong to us. So we found
In my humble submission, my lord, insurance company has nothing to do with this IA, my
Yes,
lord.
yes.
Appeal, my lord.
But still they are entitled. You have an extra copy of,
Extra copy, my lord, I can furnish, my lord, but my lord,
you furnish it to him now.
my
We
lord,
are disposing it off.
my lord,
You go through,
My
give a
lord.
copy to him.
my lord, I will furnish an extra copy.
You give your copy to him.
My lord.
Mr. Saikia, you may not have anything
Yes.
to, but you may go through the application.
as amount is already deposited.
My lord. Amount has already been deposited.
Heard me, I
Oh, yes, the appeal.
heard Mr. P. Sundi, learned counsel for the applicant. Also heard Mr. A. J. Saikia, learned counsel for respondent number 3. This interlocutory application has been filed by the applicants in connection with MAC appeal number 668/2022, seeking a direction from this court to the bank in which some portion of the awarded amount was deposited as fixed deposit in pursuant to the direction of the Motor Accident Claims Tribunal Tribunal, Sonitpur, in what is the
MSC case number, madam.
in MSC case number
65/2017
65/2017
within bracket D, madam. Death case.
within bracket D. Stop. Learned counsel for the applicant, Mr. P. Sundi,
Madam.
the learned counsel for the applicant submits that the aforesaid case, that is MSC case number 65/2017 within bracket D, was allow, allowed by the Motor Accident Claims Tribunal, Sonitpur, on 24/9/2018, whereby a compensation amount of rupees 8,72,400 was awarded to the present applicants, along with an interest at the rate of 6% per annum. He submits that as on the date of passing of the aforesaid award, the applicants number 2, 3, and 4 they were minor that time, no?
Pardon?
At that time they were minor.
My lord. Now all are major, my lord.
Were minor, the tribunal directed that the rupees 2 lakh each out of the awarded amount shall be deposited in a bank against the claimants number 2, 3, and 4 in fixed deposit for different period. It was directed that against the applicant number 2, namely Srimati Meenu Kumari, an amount of rupees 2 lakhs shall be deposited in fixed deposit for a period of 5 years. And accordingly, same was done. And same was done in which bank?
My lord, Punjab National Bank, man.
In the Punjab National Bank, which branch?
My lord, this is my lord. The white annexure 1, my lord, it pays 8, my lord. I have enclosed that and renewal of the deposit, my lord.
Which branch?
My lord, there's do we want to substitute? Delhi. Tezpur, my lord.
Punjab National
Tezpur branch.
Bank, Tezpur branch, with account number 0010109133,471 for a period of 5 years. Stop. The learned counsel for the applicant submits that the amount deposited against the claimant number 2 in fixed deposit, namely against the claimant number 2, namely Srimati Meenu Kumari, in fixed deposit in aforesaid account for a period of 5 years has matured as the said period has lapsed. However, when the aforesaid claimant approached the bank authority for disbursal of the said amount, she was informed that the bank has auto-renewed the said fixed deposit amount for another
5 years, my lord.
another 5 years. and it can be dispersed only if the court directs to do so. Stop. I have considered the submissions made by learned counsel for. Where is the impugn order in appeal?
It's an MSc appeal, my lord.
Appeal is preferred by whom?
By the claim applicants, my lord, for enhancement, my lord.
Stop. It appears that the present applicants have preferred the connected MAC appeal number 668/2022, praying for enhancement of the awarded amount. It also appears from on perusal of the impugn judgment that a sum of rupees 2 lakhs was directed to be deposited in the name of claimant Srimati Minu Kumari, within bracket, who was minor at that point of, minor on the date of, who was minor at that point of time, bracket close. For
She is not, Minu Kumari perhaps is not minor, my lord. Other two are minor at that time, my lord.
Okay, Minu Kumari, bracket to continue, for a period of 5 years only. As the said period of 5 years has lapsed, the said amount has to be disbursed to the claimant number 2, namely Minu Kumari. Accordingly, the whom direction should go? The branch manager.
My lord.
Accordingly, the branch, where is the, accordingly, the branch manager of Punjab National Bank, Tejpur branch, is directed to disburse the amount, which amount, and disburse the maturity amount which has been deposited in account number 00101091333471 with customer ID number 07320000409 to the applicant number 2, Srimati Minu Kumari, on production of a copy of this judgment by her. This interlocutory application, copy of this order by her. This interlocutory application is accordingly disposed of. What is the status in appeal?
My lord, service is not complete with regard to respondent number 1 and 2, my lord. AD card has not been received, my lord, for us. LCR has been received, but service is not complete, my lord.
Main appeal, my name may be directed to be sought.
In main appeal, heard Mr. P. Sundi, learned counsel for the appellant. You have to take fresh steps.
For respondent 1 and 2, my lord.
Yes.
My lord.
Also, Mr. A.J. Sakya, learned counsel for respondent number
3, my lord.
And learned counsel for respondent number 3. It appears that as regards respondent number 1 and 2, the service report is still awaited. Stop. As such, the appellants are directed to take fresh steps for issuance of notice upon respondent number 1 and 2 by speed post as well as by usual mode within 7 days from the date of the order. Returnable on 26th of August. Stop. The registry is directed to reflect the name of Mr. P. Sundi as the engaged counsel for the appellants in the cause list henceforth.
Much
Yes.
obliged. For respondent number 3, my lord, his name may be shown. my lord.
This is item number? No, registry is directed to reflect the name of A.J. Swekya, not P. Sundi. A.J. Swekya as the engaged counsel for respondent number 3 in the cause list henceforth.
Much obliged.
Your name is already there.
But in the but appeal in the appeal, my lord, it's not shown, my lord, or in the court list perhaps. Maybe shown.
Yes, registry is also. It is. The registry is also directed to reflect the name of Mr. P. Sundi in the cause list as engaged counsel for the appellant henceforth.
Much obliged.
Item 33.
I is disposed of.
Lordship, as per office note dated 14/7, Lordship, steps were taken, Lordship, by usual process, but service report may be awaited, Lordship.
Heard Mr. A.J. Swekya, learned counsel for the applicant. On perusal of the office note dated 14/7/2026, it appears that service report in respect of notice issued to the respondents is awaited. Registry is directed to place the postal track consignment report of the notice issued to the respondent by speed post before this court on the next date fixed. Let this case be listed on 19th of August.
Item 34.
In this case also, Lordship, as per office note dated 13/7, steps were taken.
Same order. You are appearing. Respondent number, come this side. Little more this side. Use microphone otherwise.
My senior SK is on legs.
Heard Mr. A.J. Swekya, learned counsel for the applicant. Also heard Miss R. Datta appearing for Mr. S.K. Medhi, learned counsel for respondent number. Learned counsel for respondent number 2. As regards the other respondents, the office note shows that the service report is awaited. Stop. The registry is directed to place the postal track consignment report of notices issued to the other respondents by speed post, before this court on the next date fixed. Let this matter be listed.
Lordship, as per my knowledge, Lordship, it was taken through usual process, not through resistance process.
Then you have to take steps.
There is direction to take steps, Lordship, only through there's no direction whether to AD or.
No, you take steps by. Today we will issue direction. The not all that postal track consignment report. The पढ़ दीजिए तो एक बार. No. Awaited. Stop. Await further. Stop. Next para. In the meanwhile, the applicant is directed to take fresh steps for issuance of notice upon remaining respondents by speed post within 7 days from the date of this order, returnable on 19th of August.
Item 35.
Please, Lordship.
Speed post, I believe. एक माह और gap दिखाओ madam. 1 month gap.
No steps have been taken, my lord, but notice not served, my lord.
Heard Mr. T. Kolita, learned counsel for the applicant. On perusal of the office note, it appears that the service report in respect of notices issued to the respondent is awaited. You take steps by speed post also,
Speed post was taken.
usual process mode. Await further. In the meanwhile, the applicant shall take fresh steps for issuance of notice by speed post upon the respondents within 7 days from the date of this order, returnable on 19th of August. Please.
Item 46.
May it please, your lordship. Lordship, here there is a delay of 4 days.
4.
16.
The registry had corrected it and made it 4 days.
You're opposing.
I am Kavitar, Lordship.
This is for respondent number 1 to 3, no?
You are for the claimant.
Lordship. Lordship, as for Lordship, whatever OP has been served, there is mentioned as 16 days.
60?
160 days.
16 days.
Yes.
Lordship, we have found a delay 16 days, but registry had made the correction and they have found it 4 days.
Okay, now what is your submission, Mr. Hawk?
Lordship, my the oral submissions, Lordship, whatever delays occurred, Lordship, it is a 16 days, and that delay is not day to day is not explained. So
you are opposing. Will you file a written objection? Heard Miss M. Saikya, learned counsel for the applicant. Also heard Mr. I. Hawk, learned counsel for the caveator / respondent number 3. 1, 2, and 3 claimants. This application under section 5 of the Limitation Act has been filed by the applicant insurance company, namely HDFC General Insurance Company Limited, praying for condonation of 4 days of delay in preferring the connected miscellaneous first appeal, wherein the judgment and order dated 3/2/2026 passed by the Learned Commissioner, Employees Compensation, Kamrup, in EC case number 20/2021 has been impugned. Learned counsel for the petitioner has submitted that. Learned counsel for the applicants has submitted that the cause for delay in preferring the connected appeal has been stated by the applicants in paragraph number 2 of the instant interlocutory application, and same may be regarded as sufficient cause, and the prayer for condoning the delay may be allowed. On the other hand, learned Mr. S. Hawk, Mr. I. Hawk, learned counsel for the caveator / respondent has submitted that though the respondent are not inclined to file any written objection, however, they are objecting to the condonation of delay caused in filing the connected miscellaneous first appeal by the insurance company, as the delay has not been sufficiently explained by them. Stop. I have considered the submissions made by learned counsel for both sides. and have gone through the reasons shown in paragraph number 2 of the interlocutory application for delay in preferring the connected miscellaneous first appeal. After going through the reasons shown therein, this court is of considered opinion that same may be regarded as sufficient cause which prevented the applicant in preferring the connected appeal within the prescribed period of limitation. As such, the delay of 4 days in preferring the connected appeal is hereby condoned and this interlocutory application is allowed. The registry is directed to register the connected miscellaneous first appeal and list the same for admission on 5th of August. The name of Mr. I. Hawk may be reflected in the cause list as counsel for respondent number 1, 2, and 3. Stop. This interlocutory application is accordingly disposed of. Caveat stand discharged.
Lordship, can this matter be fixed on 21st of August?
21st of August instead of 5th or 21st.
I left. Item 47.
37, Lordship, analogous matter.
Same,
Lordship.
4 days.
same 4 days.
Yes.
Same order. Same order.
Lordship. Both matter may be checked.
Yes, can be checked today.
No, but first it has to be registered.
Lordship.
We don't know the numbers.
Lordship.
Let it be registered.
Obliged, Lordship.
Yes.
Yes, my lord. This is an IA for delay condonation of 246.
When counsel for the petitioner, this application under section 5 of the Limitation Act has been preferred by the applicants for condoning the delay of 2464 days in preferring the connected MAC appeal. Let the notice be issued. The applicants shall take steps for issuance of notice on both the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 24th of August.
Alia.
There is a delay of 239 days in preferring the appeal.
Same order, A. Bhattacharya, and next date is 24th August.
Obliged.
Issue.
Here also delay of 103 days.
Same order, 103 days. See. Next date is 24th August.
Obliged.
Item 41. Wait, please, Lord. So, I for delay condonation, my lord, 256 days notice will go.
MSc.
MSc, man.
Same order, S. Das. 256 days delay. Next date is 26th August.
Highly obliged. 47 from supplementary list.
Make business your Lordship. Lordship, as per office note dated 16/7/26, LCR received. Respondent 2 has appeared. Already 1 was appearing.
Yes.
So service is complete. It can go for appearing, Lordship.
Third, Ms. R.D. Majumdar, learned counsel for the appellant. Also, Mr. A. Bhattacharya, appearing for respondent number 1, as well as Mr. M. Islam, appearing for respondent number 2. It appears that the record of the concerned MAC case has been received, and hence this appeal is ready for hearing. List this matter for hearing. You want a fixed date?
Yes.
15th October.
Alia plus.
Lordship, hearing for appellate, sir.
Record सही से. How many respondents are there?
Respondent 11.
Lordship, I am appearing for respondent number 3, 4, 6, 7, and 11. 6, 7, and 11 today we have filed Wakalatama.
And Mr. Gogoi, you are appearing for?
Lordship, 1 and 2.
Who is appearing for 8 and 9? Heard, Mr. What is your name?
Sir, B Das. Lordship B Das.
Heard, Mr. B. Das, learned counsel for the appellant. Also heard, Mr.
C. Sharma.
C. Sharma, appearing for respondent number 3, 4, 6, 7,
And 11.
and 11, as well as Mr. T. R. Gogoi, learned government counsel, appearing for respondent number 1 and 2. It appears that service report in respect of notices issued to respondent number 9, respondent number 5 and 9 are awaited. Who are 5 and 9?
Number 5 is chairman. Assam Small Industrial and Corporation.
You take fresh steps against 5 and 9 by speed post.
Last time, Lordship, we have taken the steps
By
on 5 to 11.
by which mode? Usual mode.
By speed post also by usual.
But office note does not reflect that you have taken steps by speed post. Office notes shows that you have taken steps by usual mode only. You take fresh steps. The appellant is directed to take fresh steps for issuance of notice to respondent number 5 and 9. 1, 2, 3, 4, 5, 6, 7, 8. 5, 9, and 10. 5, 9, and 10 by speed post within 7 days from the date of this order, returnable on 26th August. List accordingly.
Replay, please.
May please, Your Lordship. Regular first appeal, Your Lordship, statutory appeal. Notice was earlier issued, but not admitted the appeal. The LCR was called for. I have taken steps, but not served.
When you have taken steps,
Lordship, it was long back, Your Lordship.
you take fresh steps.
Lordship.
Heard Mr. A. R. Shown, learned counsel for the appellant. It appears that The service report in respect of notices issued to respondents is still awaited. The appellant is directed to take fresh steps for issuance of notice upon the respondents by speed post as well as the usual mode within 7 days from the date of this order, returnable on 26th of August.
Lordship, I may be allowed to take steps in both the addresses, Your Lordship. Two addresses I have given, one present address and one permanent address.
Appellant is directed, appellant may take steps for issuance of notice on both the addresses of the, how many respondents are there?
Lordship, in the appeal, only one respondent.
Of the respondent given in the memo of appeal.
Lordship may be admitted the appeal, Lordship, and LCR may be called for, LCR earlier called for, Lordship, but not received.
The appeal is admitted. Stop. Let the trial court records be called for registry to take steps for requisitioning the trial court records. List accordingly on 26th August.
Lordship, IA is there one, along with this appeal. In the IA, Lordship, it is shown in the office note that steps on usual service, it was taken, that was served.
Served?
Yes, it is in the office note.
Have you checked?
I checked, Lordship, in the morning.
Ranjan, it is not served, it is issued only.
In the IA, Lordship.
On what basis he?
Lordship, in the IA, I may be allowed to take in steps, Lordship. I also.
In IA also issue notice, same. The applicant shall take fresh steps, same order.
Oblige, Lordship.
Item 2.
Make your Lordship. Lordship, today I'm praying for an adjournment because my lord, the case has been listed without showing my name, my lord. Just after reaching court, I came to know that case has been listed. Maybe the next week, my lord, any date may be fixed.
No, we'll admit the appeal.
It may be admitted, my lord.
This is for the first time it is coming.
Earlier it was filed.
Delay was condoned.
Delay was condoned. But after condonation, it is coming
time.
for admission.
First time, yes, first time.
Heard Mr. T. Kolita, learned counsel for the appellant. Also heard Mr. D. Mondal, learned counsel for respondent number.
Claimant respondent.
Learned counsel for the respondents / claimant.
1, 2, and 3.
1, 2, and 3. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant Cholamandalam MS General Insurance Company Limited, impugning the judgment and award dated 3/5/2025 passed by the Motor Accident Claims Tribunal number 2, Kamrup Metro, Gauhati in MEC case number 565/2018, whereby the appellant was directed to pay a compensation amount of rupees 13,28,246.16 along with an interest at the rate of, how much was the interest?
9%.
At the rate of 9% to the claimant respondent. I have gone through the grounds of appeal. Grounds stated in the memo of appeal. This appeal is admitted. Let notice be issued to the respondents. Since Mr. D. Mondal has already appeared for respondent number 1, 2, and 3, no formal notice need to be issued to the said respondent. However, the appellant shall take steps for issuance of notice upon respondent number 4 and 5 by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th August. Stop. Name of Mr. T. Kolita, may be reflected. The registry to reflect name of Mr. T. Kalita as engaged counsel for the appellant in the cause list, henceforth list accordingly.
TCR may be called for, my lord. TCR.
The records of MSC case number 565/2018 be called for from the concerned tribunal. The registry shall take steps for requisitioning the records list accordingly.
Regarding stay, my lord, maybe taken up on the next date, my lord, because I have seen the file, my lord. There is a dispute regarding the involvement of the vehicle, my lord.
Okay,
Then one thing can be done, they may be directed to deposit. Release order may not be.
Today, my lord, I don't have the brief, my lord. I have just
Okay,
seen the brief, my lord.
we'll not stay it. In the next date, we'll consider the stay
My lord.
application.
Let me get it.
Let him come prepared.
Obliged.
Highly obliged.
Made the lordship, in this case, lordship, appellant is directed to pay compassionate, 71 and something.
Two? No. Appeal by, this is an appeal by claimants.
Actually, yes.
Your claim was dismissed.
Lordship, this-
Claim was
Yes, your lordship. Not
This-
this lordship, actually imposed me, actually I am not in the.
Wait.
Okay, lordship.
whether a claim was dismissed or not.
Yeah.
You have to, no, it was not dismissed. You have to answer that I don't know. I have not gone through the brief because it was allowed. Heard Mr.
J.M. Sulaiman.
J.M.
Sulaiman.
J.M. Sulaiman, the learned counsel for the appellant. This appeal under Section 173 of Motor Vehicles Act 1988 has been preferred by the appellant Sarifuddin Chaudhary. You are not the claimant.
Not claimant.
Sarifuddin Chaudhary, impugning the judgment and order dated 24/2026 passed by the Motor Accident Claims Tribunal Kachar in MEC case number 227/2018, whereby the present appellant was directed to pay
71.
compensation amount of rupees 71,173 along with an interest
9%.
at the rate of 9% per annum to the claimant respondent. I have gone through the grounds taken in the memo of appeal. This appeal is admitted. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as the usual mode within 7 days from the date of this order, returnable on 26th August. Let also the records of MSC case number 227/2018 be called for from the concerned tribunal. The registry shall take steps for requisitioning the records list accordingly. I am taking a short break. Bill PPSA. We'll take it up after at 12 it was fixed. Okay, we'll take up bail matter.
Let me give the basic facts first, my lord.
May it please your lordship.
Yes.
Well, this man was arrested on 18/2/2025. Both the petitioners. So the total number of days as on date is 1 year, 4 months, 29 days.
Yes.
Total number of witnesses is 12. Total number of witnesses 12.
Yes.
Number of witnesses examined so far is none.
Yes.
Charges were framed on 3/10/2025. The charge sheet of date. Charge sheet of date. Charge sheet of date. Now, my lord, the quantity alleged.
Is it your first bail application?
No, this is my second bail application. There is an IA, my lord. In that IA, we have annexed that the earlier rejection order. Not IA, sorry. Additional affidavit. I'm saying IA. I'm sorry. There is an additional affidavit. There are in fact 2 additional affidavits. The additional affidavit dated May 2026. We have already annexed that copy because, my lord, when we have initially filed it, we were not aware of this. But however, my lord, on the day when this matter came up and when we have come to know, we have in fact intimated the court that there is an earlier order, and subsequently the court allowed us to file an additional affidavit. We did it and we have brought this on record. Yes, my lord.
Yes.
The contraband recovered is allegedly to have been recovered is 739.19 grams of heroin.
739.
0.19 grams of heroin. 250 is the commercial quantity.
Yes.
Now, my lord, primarily, my lord, I am seeking bail on 3 major counts, my lord. Number 1 is there is a gross violation of Section 36 of the BNSS. Second is there is a violation of Article 22(1) inasmuch as he was not produced within 24 hours of his physical custody. And ground 3 is prolonged incarceration.
Yes.
Now, my lord, to address the first ground, my lord, may kindly come to page 61. Now, my lord, before that, I'll show where the interception according to them was made. The interception was made at Khanapara, and that your lordship will find from their offense report at page number 19. Page 18, para 3, it starts. Khanapara, your lordship will find at page 19. Your lordship is there, my lord?
Yes.
Your Honor, a team comprising of officials of the DRI so-and-so planned to intercept the white so-and-so with occupants accordingly on 18/2/25. At about 8:30 hours, the officers positioned themselves along with 2 independent witnesses near Khanapara flyover and kept strict vigil on the vehicle coming from Jorabad side at about 9 hours on such and such. So, my lord, it is intercepted at Khanapara, my lord, which is evident from this, their own offense report, my lord.
Yes.
Now, my lord, will kindly come to the arrest memo at page 63. BNS section 36.
Yes.
Now, my lord, this arrest memo is signed by two witnesses, Lordship will see below, as Banerjee, or Bhomrajji or Banerjee, my lord, I can't, my lord, Banerjee. As Banerjee, your Lordship has seen page 63 down below.
Yes.
As Banerjee and Sirajul Haq, Sijaul Haq. My lord has seen those two signatures.
Yes.
As Banerjee and Sijaul Haq. Now, my lord, kindly turn to page 61. My lord is there at page 61.
Yes.
This is the list of witnesses which is appended to the offense report. Witness number 2 is Samrit Banerjee. Independent witness, what he does, we do not know. My lord will kindly see his address. Lal Ganesh Udal Bagra.
Yes.
And my lord will kindly see Siajul Haq's address. Maranjana Kamrup. Maranjana is under Rongia subdivision.
Yes.
My lord. BK Bosude. My lord, this is the factual position and these are documents. They are documents. Now, my lord, may I?
Total BNSS there.
My lord, I'll refer one paragraph here and then I'll go to BNS, my lord, section 36.
Yes.
My lord will kindly come to. My lord will kindly come to para number 35(2). Internal page 435, my lord. These are the direction.
Yes.
Para 35. We therefore considered it appropriate to issue the following requirements to be followed in all cases of arrest or detention till legal provisions are made in their behalf as preventive measures. Because at that point of time in 1986, when this case was rendered, there was no parallel legal provision. Direction number 2, my lord. That the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness, who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. It shall be also countersigned by the arrestee and shall contain the time and date of arrest.
Yes.
Now, my lord, this direction was incorporated in the CRPC in the year 2010 as section 41 capital B.
Yes.
After the BNS has come into force, the perimeter section is section 36.
Yes.
B. My lord is there?
Yes.
Prepare a memorandum of arrest which shall be attested by at least one witness who is a member of the family of the person arrested or a respectable member of the locality where the arrest is made. Now, my lord, none of them are family members, neither from the locality, least to speak about respectability. Now, my lord, your lordship has seen that.
Okay, your submission is that they were not from the
Neither family member nor locality. Now, my lord, a question arises whether this requirement will have any bearing on Article 21. My lord will kindly revert back to DK Bosu, para 37. It may be just a statutory requirement. Maybe if it is not, it may not entail a bail per se. Kindly turn to para 37 of this DK Bosu.
Yes.
Para 37 of DK Bosu, my lord, kindly. My lord is there at para 37.
Yes, 37.
37. It talks of the requirement under para 35. The requirements referred to above flow from Article 21 and 22(1) of the Constitution and
Yes.
need to be strictly followed.
Yes. So what was not followed in this case?
In this case, what was not followed is that the signature neither of the family members nor of the person from the locality needs to
Family
speak
members or
locality.
or that is optional.
Absolutely. Locality.
What
Ronia cannot be locality of Khanapara. Locality of the place from where they are arrested.
what locally?
He was arrested from Khanapara. That is what I have showed, my lord, from the arrest, from the offense report, that para 3. Para 3 at page number. Para 3 at page number. Page 19. That they were arrested from Khanapara.
Okay.
Now, my lord, the arrest memo which I have showed at page number 63 bears the signature of this Banerjee and Haq.
Whether they are the person
Yes.
whose signatures were obtained.
Yes, my lord. These are the two persons which your lordship will find at page 61.
They may have alternative address in that locality, which.
My lord, if a person alleges that my fundamental right is violated, on whom the burden lies to prove it? I am showing a contemporaneous document, prima facie their document, which shows that the arrest is from Khanapara, the person is one is from Rongia, that is Kamrup, and the other is from Udal Bakra. Prima facie I am demonstrating.
Okay.
Now the question is on whom the burden lies? Because, my lord, a man who is distressed in custody, how he would prove? And my lord will kindly come to, this is perhaps my lord is holding Vihan Kumar.
No, this is mandatory.
Pardon, my lord?
Is it mandatory that
Yes.
that witness has to be from that locality only?
Yes. Yes. That to that extent, the language used in DK Bosu, my lord, the one which I have referred to, para 35, direction number 2, the word used is locality. And that is the precise reason, because they have pocket witnesses. The court has taken that into account. I am again reading, my lord, para 37, direction number 2, that the police officer carrying out the arrest of the arrestee shall prepare a memo of arrest at the time of arrest, and such memo shall be attested by at least one witness who may either be a member of the family of the arrestee or a respectable person of the locality from where the arrest is made. This is to cater a situation where police officer will have their own pocket witnesses. They will give them telephone call. They will come to the police station and they will sign everything. And when they are put to cross-examination, we do not know what we have signed. These are the normal trend. So therefore, to take care of those situations, the Supreme Court has made it very clear that it is, they not only say locality, it also say respectable. My lord, Khanapara, 9 a.m. morning, they say they have intercepted. Khanapara comprises of n number of educational institutions, hospitals. I don't say that a doctor should leave a patient and come. Maybe a person who works in that hospital. It has vehicle showrooms. Maybe a manager from the vehicle showroom.
Okay.
So now, my lord, when somebody alleges violation of fundamental right, then on whom the burden lies?
Okay.
And not only this is there in DK Busu, this was the locality, and respectable person from the locality is also there in 41B of the CRPC, which is now, my lord, parameteria is 36 clause B of the BNSS. These two words are still intact, locality and hearing, and that respectable person or a family member. either of them. And their document prima facie demonstrates that one is from Udal Bakra and the other is from Rongia subdivision.
Okay.
So now, my lord, on whom the burden lies? That now I am alleging that this is violation, and prima facie I am showing certain documents which are their documents. My lord, this is my lord, may kindly take up, my lord, one paragraph of Rehan Kumar. No, which one you have? This one and this one. Okay, both. Rehan Kumar, my lord, kindly come to para 21. I am not on those other aspects of Rehan Kumar, that 47, 48. I am not on those aspects. Para 21, my lord, where the
Yes.
my lord, these are the conclusions, the summary, my lord. Kindly come to the point number C, 21C.
Yes.
Internal page 15. My lord, is there, my lord?
Yes.
Kindly 21C.
Yes.
My lord, when arrested accused alleges non-compliance with the requirement of Article 22(1), my lord, now this is also a requirement of 22(1) as far as DK Basu, my lord, para number 37.
Okay.
The burden will always be on the investigating officer to prove compliance with the requirement.
Yes.
Now, the same principle was reiterated in the other judgment, and then I'll make my submissions on the fact. My lord, this Kasi Reddy, Upender Reddy, my lord.
Yes.
My lord, may kindly come to para internal page 21, para 18, G. My lord, is there at G? When an arrestee pleads before the court that the grounds of arrest was not communicated, the burden to provide the compliance of 22(1) is on the police authorities. So, my lord, the point which I am trying to make, when there is an allegation of violation of fundamental right, maybe in the nature of grounds of arrest, maybe in the nature of not produced within 24 hours, maybe in whatever nature, the burden is always on the prosecution to prove, because the man is behind the bar. How can he prove his innocence at that period of time?
Yes. Yes.
Now, my lord, if from their document, from any contemporaneous document, if they can show, not by oral submissions, my lord, by some contemporaneous document from the records which has been produced before this, the TCR, if they can show that these two persons are from that locality with some repute, I don't ask for with some repute, my lord, from that locality, if they can show, this ground will get negated. But if they cannot show anything from the contemporaneous record that these persons are from Khanapara, from the place where they were arrested, then perhaps, my lord, my submissions will be, my lord, your lordship will accept my submission. This is my ground number 1.
Yes.
Moving to ground number 2, that they were not produced within 24 hours. Now, my lord, before urging that ground, my lord, one or two things, my lord, I'll just try to, Nazib, Justice Krishna, I have judgment, his lordship's judgment also. His lordship's judgment, Krishna has judgment.
Yes.
My lord, when a person can be said to be in custody, or when a person can be said to have been arrested. Now, my lord, Your lordship has time and again, my lord, your lordship might have, your lordship, I'm sure your lordship has gone through this judgment. Just for my sake, my lord, one paragraph 7, the last sentence, last but the one, the penultimate sentence, paragraph 7, my lord, is there, my lord. It says, when is a person in custody within the meaning of 439 CRPC? My lord, is there?
Yes.
When a person is in custody within the meaning of section 439 CRPC, answer is when he is in duress, either because he is held by the investigating agency or other police or allied authority, or is under the control of the court, having been remanded by the judicial order or having offered himself to the court's jurisdiction. My lord, I'll skip. So, my lord, if I have understood the first line correctly, then the Supreme Court poses a question that when a person can be said to be in custody for the purpose of bail application 439, and it says when the person is in duress or when he is under the control of the police authority. When he is in duress or he is held by the investigating agency. Just, my lord, will skip the in-between line and then come to the equivocal quibblings. My lord, is there, my lord?
Yes.
The equivocatory quibblings and hide and seek niceties, sometimes heard in court, that the police have taken a man into informal custody, but not arrested him, have detained him for interrogation, but not taken him to formal custody, and other like terminological dubities are unfair. My lord, will kindly see the word and the phrase used, are unfair evasion of the straightforwardness of the law. Meaning thereby that those niceties of word, that no, I have taken him for interrogation, I have not taken him, I have not formally arrested him, that this is an informal custody. Supreme Court says these are unfair evasions of the straightforwardness of the law.
Yes.
Now, my lord, I was putting a question to myself when I was preparing this, my lord, that it speaks of custody within the meaning of 439. There is, as such, my lord, maybe an arrest during investigation and a custody for the purpose of 439. Maybe there may be some difference, my lord, or some distinctions. 2008. My lord will kindly take up the next judgment. 2008, 3 SCC 222. As this judgment is there, para number 23. Supreme Court has said the meaning of custody and arrest are same as para 23. Para 23. Because a distinction was tried to be made by a full bench of the Madras High Court that the meaning of custody as held in that other case, 1980 case by Justice V.R. Krishna Iyer, that was in terms of custody for the purpose of 439 and arrest are two different things. A distinction was tried to be carved out, my lord. Para 23, Supreme Court says, in our view, the law laid down, we are unable to appreciate the view of the full bench of the Madras High Court and reiterate para 23.
Yes.
We are unable to appreciate the view of the full bench of the Madras High Court and reiterate the decision of this court in Niranjan Singh case. That is the other one, which I have just now relied on. In our view, the law relating to the concept of arrest or custody has been correctly stated in Niranjan. So, arrest and custody, as explained in Niranjan, will prevail. Meaning thereby that those niceties of word, informal arrest, for the purpose of the issue is whether he is within the physical control of the arresting authority or not. Whether he is in duress or not, the word duress is used.
So you have to show something.
Absolutely. Now I will, my lord, I will show that these petitioners were in the physical custody. Now, my lord, why this point assumes importance in this case is because of this, my lord. Because I will show, my lord, that this man was in physical custody or in duress of the DRI official prior to 24 hours from their production. So if I can show your lordship the time when he was arrested or when he was in custody in terms of the decision rendered by the Supreme Court, and then if I can show your lordship that he was produced beyond that 24 hours, perhaps, my lord, your lordship will then be convinced that there is a serious violation of 22(1). Now, my lord will kindly come to the factual part. My lord will kindly come to page 19 of page 9. But I'll start from this para 3 of page 18 because 19 is a continuation of
Yes.
this is from their offense report. Your Honor, a team comprising of officials of DRI Gauhati Zonal Unit planned to intercept the white Mahindra Bolero camp bearing registration number such and such with occupants. Accordingly, on 18/2/2025, at about 8:30 hours, the officers positioned themselves along with two independent witnesses near Khanapara flyover and kept strict vigil on the vehicle coming from the Jorabad side. At about 9 hours, my lord will kindly take note of this. At about 9 hours on 18/2/2020, the officials so-and-so matching the intelligence coming from Jorabad side, the DRI officer signaled and the said white Mahindra Bolero camper vehicle bearing registration number so-and-so to stop, and the white Bolero vehicle bearing so-and-so stopped along with roadside near Khanapara flyover, Gauhati, Assam. Thereafter, the DRI officer along with the two independent witnesses approached the said white Mahindra Bolero such and such while bearing registration number, and it was seen that there was two persons inside the said white Bolero camper vehicle, one male person behind the wheel and another male person in front of the passenger seat. The DRI officers, after introducing themselves and the two independent witnesses, requested the two intercepted person to introduce themselves, to which the person behind the wheel introduced himself as so-and-so and so-and-so Manipur, and sitting on the front page, that the said intercepted vehicle introduced himself as so-and-so and so-and-so. They reached at 10 p.m. Where is that? Page number 20. Yes. Your Honor, the DRI officer asked both the intercepted person of the said vehicle, camp vehicle, so-and-so, so-and-so, whether they were carrying any contraband in the said vehicle. Thereafter, the DRI officer informed both that they have specific intelligence that narcotic drugs at 10 a.m. to Kota, sir. My lord, I'll show that at 10 a.m. The person has the intelligence officer has specific intelligence. 10 a.m. to Kota, sir.
21.
At 10 a.m. Yes, my lord. It is at page 21. That by 10 a.m. they were already in the DRI office. Page 21. As per the record, the witnesses also accompanied the DRI officials. So those witnesses accompanied them to the DRI official, and two apprehended persons along with their personal baggage and such were reached DRI office at about 10 hours. 10 a.m. they reached the office. Now, my lord. Now, my lord will see the case of the DRI. Page number 29, my lord will see. So, my lord, until now what we have seen, according to them, at 9 a.m. they have intercepted me, and by 10 a.m. they have brought me to the DRI office of 18/2/2025. Now, my lord, kindly come to page number 29, yes. My lord, page number 29, your lordship is there at page 29?
Yes.
My lord, the line which starts from, however, he does not remember the Google, as planned. My lord is there, my lord, as planned?
Yes.
My lord will kindly mark this. Now, my lord, we'll see, here the journey starts from Chorachandpur, Manipur. As planned, at around 11 a.m., on 15 to 2025, the date my lord will kindly mark, 15 to 11 a.m. the journey starts.
Yes.
They begin their journey from Leon, alias such as, this is the main accused person according to them. Otherwise also we are the driver and the handyman. No, owner and the handyman. Begin their journey from Leland, alias such and such place in Koti, Chorachandpur to Gauhati via Aizawl. There were 4 of them in the vehicle, namely such and such, such and such, such and such. They arrived Aizawl approximately 10 p.m. on the same day. So they started at 11 a.m. from Chorachandpur, Manipur. On the same day, that is 15th of February, they reached 10 p.m. they reached Aizawl. His friend, Lalro friend Mouse had already booked hotel room at such and such in such and such Aizawl. They reached the hotel room at 10:30 p.m. My lord, such meticulous investigation, my lord. It's very rarely we see such precision. 11 started morning, 10 p.m. reached Aizawl, 10:30 reached hotel. Now, my lord will see, next day on 16 to 2025, my lord, I'll skip all this. These are irrelevant. I just want to show the sequence of journey. My lord, may straight away come to page 30, the line which starts from on 16 to 7th line.
Yes.
My lord, is there on 16 to?
Yes.
On 16 to, they departed from their hotel such and such at around 12 p.m. Exact time, 12 p.m. from Aizawl hotel. This time, both such and such, my lord may skip all this thing. Now, my lord, I'll just take a pause, my lord, here. My lord will just see, my lord. 11 a.m. they start from Manipur, Chorachandpur. 10 p.m. they reach Aizawl. 10:30 they reach hotel. Next day 16:12 they start from Aizawl. Now, my lord will see, for 45 hours there is no investigation. And then I will come what have actually happened. Just come to para number 7. Now suddenly they straight away jump on 18. On early morning hours of 18 to 2025 at around 9 hours when they reached near Khanapara flyover. So if your lordship calculates the time from 12 p.m. Aizawl to 9 p.m. Gauhati, it is 45 hours. My lord, I do not know whether they were coming by bicycle or some other mode of communication. Because 45 hours by no stretch the distance between Aizawl to Gauhati. Now, my lord, why I am making this submission? Because, my lord, they were arrested at the midnight 1 p.m.
On which date?
On 18th, 12:30 to 1 p.m. they were intercepted. Now, your lordship may ask me from where I am making this submission. My lord, I have consulted my client and made a statement on the affidavit. They spoke with my junior. They said, हम लोग को 1 बजे रात को arrest किया. This is the precise line used by them. And I will further show their manipulations. And that is the reason why for 45 long hours, before that,
No,
even
at 1 p.m. on which date? 18.
on 18, 1 p.m., no, sorry, 1 a.m., midnight.
Okay, not at 9 p.m.
No, not at 9 a.m. They are saying 9 a.m. Both are morning hours. They are saying 9 a.m.
10.
It was arrested at 1 a.m.
That is your story.
That is the instruction which I have for my client, which has been, which, and there is an affidavit to that extent, my lord. I cannot have more evidence than that, my lord. I am in their custody, physical control.
Yes.
My mobile phones are seized by them. I cannot even take a photograph. Now, my lord, please read this para along with their memorandum of arrest and kindly see what time they have written in their arrest memo at page number 63. At page 63, my lord, will kindly see at what time the arrest is shown. Huh. 63 is petitioner 1, 64 is petitioner 2, same, identical.
Yes.
At what time they is arrested by me at 20:30 hours. That is of 18-2. After 12 hours, they are showing arrest by, if you go by their version, after 13 hours. Sorry, after 12 hours. 9 a.m. intercepted and they are showing arrest at 8:30 in the evening. This is enough of a proof that they are manipulating things. They are doing this just to save that 24 hours time. They could have produced him the very next day. On 18th evening, they could have produced. My lord, if I remember one judgment passed by your lordship, where your lordship was considering a case where the accused is in hospital. And then your lordship passed a direction that even in those cases, the magistrate may visit the hospital or there can be a video conferencing. That judgment also, my lord, I am having. That is the observation passed by your lordship. Here is a case for 45 of till Aijol, they have 30 minutes detail. They are having 30 minutes even detail. 10 o'clock Aijol, 10:30 hotel, 12 such and such. 45 minutes silent, 45 hours silent. Suddenly 9 a.m. in the morning. Even if I assume that it is 9 a.m., then also there is a delay. Because they were produced after 1 p.m. On 1 p.m., they were brought to the court and they were kept in the PI. That statement I have made, and I'll show the order passed by the court below, the order of the first remand. Now, my lord, the other day, my lord, I was arguing a case in the Aijol bench, my lord. My lord, the order passed by the magistrate, the first remand order passed by the magistrate, it even bears the time. Arrested such and such, produced before me on such and such, act such and such. It becomes easy for us to defend clients. But here, they don't mention the time. They simply mention the date. Now, a direction is passed by this honorable court, which is circulated through the registry to all the, my lord, judicial officers in the state of Assam, that on the first remand order, not only the date, the time should also be there.
Yes.
Now, the issue is this, my lord. Because something has been not done by a learned magistrate, something is not done by the investigating officer, which is required to be done under the law. Should the accused be a...
No. But suppose there is a violation of that direction by some magistrate by not mentioning the time. You have to show something to convince the court that you were actually produced at 1 p.m. What is it?
Now, my lord, the accused who is in the custody of the police, he has no access to any documents. Kindly appreciate, my lord, he cannot make an application from inside the custody. Even if he makes, it will be in the dustbin. He do not, these are the practical situations, my lord.
No.
He can only speak to his advocate.
Otherwise, in every case, accused may take this plea that I was produced after a...
No, my lord. Why? How can it be? For example, my lord, if he was produced on 18 at 5 p.m. or 7 p.m. in the night, can he take this plea? Can he ever take this plea? 9 p.m. Let me assume they're correct. 9 a.m. morning. Produce him on the same day, 9 a.m. Do the formalities later on. Comply with the mandate. He could have been produced.
Your submission is that you were produced at...
After 1, he has forgotten, but he said in the afternoon we were taken, and I have made the statement in my affidavit. And normally, my lord, to whatever little we have seen, my lord, in production in Kamrup courts are always the last part of the job. Initially, court proceedings, the productions are normally at 4:30. These are the production time in 99.9% of the cases. I can say from my little experience, my lord. Morning hours, my lord, there is, unless and until there is some media high profile case, all productions are post lunch. Because that is quite understandable, my lord, because the learned magistrate, they have the judicial work to be done. Now, this is my
second submission.
Second submission, that he was produced beyond 24 hours. and I'm relying on their offense report 9 AM interception, and their, well, had their intention been clear, why they have mentioned this 8:30 PM in the arrest memo? I mean, if the benefit of benefit of doubt, if it to swing in favor of the prosecution, then that arrest memo, if they would have made some contemporaneous time in the arrest memo, then some credence to the prosecution. That no, they were fair. They're absolutely unfair. After 12 hours, they are showing he has been arrested. This is my third Lama and that enforcement director judgment. Now here is a case, my lord, where your lordship has there was a delay of 2 hours in production, bail was granted. Same. Arrest memo showed something else. But since he was arrested from an airport, so there were CCTV cameras and all other things, my lord. I said, no, 11 AM, you have taken his physical custody. You have produced him beyond after 2 hours. I'll just straight away come to para number 6.
No, in your case,
yes,
apart from your statement on affidavit that you had produced after 1 PM, what else is there?
Court does not open before 10:30.
That is so okay. So 9 arrests, you were in custody at 10. You were produced before in the office at 10 AM. So your production ought to have been before 10 AM next day. That is the submission.
That is my submission. Court does not, that is the, I mean, beyond that, my lord, a person who is custody is helpless. He cannot bring more evidence than that. And
where is the judgment which requires the magistrates to mention the
yes,
time of arrest?
yes.
That is to be
Yes. In Aijol, they are doing it.
No, this has to be done here also.
Here also already direction is passed. I thought of bringing that as a specimen, but then this is the direction your lordship will find at page number 20. After bail was granted, everything finished. Then page 20, para 20. My lord, is there a para 20?
Yes.
However, if there is a material to indicate a formal apprehension, custody prior to formal arrest, then the speed of the review would be necessarily calculated. Yes. Now, my lord, para 20 is on the fact, it says, excluding and producing the accused beyond 24 hours from the, then the same would violate the spirit of underlining Article 22. Of course, if the factual situation indicates that the formal arrest prior to arrest, if the factual situation indicates no formal arrest prior to arrest, then this is no difficulty in calculating the period from the time of the. However, if the material to indicate a formal arrest, custody prior to formal arrest, formal apprehension, custody prior to formal arrest, then the spirit of Article 22 would necessitate calculating the period of 24 hours from the date and time of such formal apprehension and custody. And the direction is para 30. Point number 1 and 2. It is incumbent on the police as well as the magistrate to mention not only the date but also the time.
Yes. No, this was not followed in this case.
Yes.
Whether it was circulated.
My lord, this is the law which was there since long back. Now, because my lord, ground of arrest and everything, this was since the constitution are enacted. Only when the Supreme Court or our High Court, they are just reiterating or reinforcing the same right. It is nothing new that they have.
What I am on is that requirement of specifying the time of production by the magistrate.
Now, my lord,
Had the magistrate mentioned the time of production,
no,
it would have been easier for.
absolutely. That is why. Otherwise also, 10 a.m. he's in office, no court, my lord, to whatever little I understand, normally courts open at 10:30 and court functions by 11 o'clock.
No, production may be made in
the home also.
Residence also.
Absolutely. The production order says it was not. The first remand order I have annexed. My lord will kindly see the first remand order. It does not say that he was produced. My lord will kindly take up the first remand order. Where is that? My lord will kindly take up my additional affidavit. None of my affidavits are dated. That is. It is May 26. The first remand order, your lordship will find running page 103. This is in chamber, my lord. These are, I mean, in the courtroom, not in residence. My lord is checking the original record, my lord.
No, the first remand order 103.
103, yes. Accused so and so, so and so, so and so, so and so, so and so are produced before me under arrest in the instant case for contravention of such as peruse seizure list, appoint a suitable magistrate for inventory, remand the accused to judicial custody, allow deposit malkhana. IO has justified the arrest of the said that both of them involved in illegal trade. One is a driver, other is a, those are factual things, my lord. IO prayed to remand, book the other accomplices working behind. These are, my lord, these are normal that follow Arnesh Kumar, again remand, nothing has been done. Further the prayer.
So on perusal of this order, it appears that he was produced on 19.
On the court.
But when he was produced, this is.
It is not there.
Not
It
there.
is. The magistrate ought to have mentioned it.
And which is very crucial in
Very
such
crucial.
cases. Okay.
So because now this lapse is to be read with on whom the burden lies, on that principle.
Okay.
This lapse read with the principle of on whom the burden lies for violation of fundamental right.
So your submission is burden lies on prosecuting agency.
Yes, my lord, that is by submission in terms of the order passed by the direction passed by the Supreme Court in Vihan Kumar and Kesava Reddy.
Okay. Okay.
These are, and this enforcement, my lord, that judgment, my lord.
Subhash Sharma.
Yes, that your lordship has read it many times, my lord. I will not disturb.
What you want to say?
I want to say here also, my lord, the formal arrest was shown something else. But he was apprehended at 11 hours on 5th of March 2022. And he was produced at 1 p.m. perhaps, after 24 hours. And not that next day, only few hours difference. That much, I guess, my lord, I'll just, the physical custody of the respondent was taken over by the appellant from the Bureau of Immigration at 11 hours of 5th May, such and such. There at 1:15 hours, 2.5 hour difference. 1:15 hours he was produced. And in the arrest memo, it was shown 3 p.m. 11 p.m. he was taken from the Bureau of Immigration. His custody was taken. Similar.
And your case is though you were produced at 10 a.m. in the
DRI office.
DRI office as per their own statement in the complaint. But your arrest was shown to be at 8:30 p.m.
PM. Yes.
And in your affidavit, you have stated that you were arrested at 1 a.m. in the previous night.
In fact, my version is more akin with the sequence of events. 45 hours it does not take, my lord. It hardly takes from Mizoram, if somebody, from Aizawl, if somebody takes few hours of nap, even by 30-35 hours is more than sufficient.
Provided there is no halt in between.
That is what I'm surprised.
But there may be halt. We don't know.
My lord, they had investigated till Aijol, even 30 minutes investigation is there.
Okay, thereafter they have not.
Thereafter, they are 45. So these are indicating, the things are indicating something fishy.
Yes.
Because till Aijol, you.
Okay, okay, I have
my lord,
understood.
And the second year rejected also.
Last, this prolonged incarceration.
My lord, one year. Now, my lord, there was one judgment by your lordship. This is why I am referring to this. This has a separate bearing in my lord. In this case, my lord, initially this case was moved by me as a counsel. Now, my lord, at that point of time, I did not take the plea of that 24 hours. Then after 1 year, this bail application was filed. After 1 year of incarceration, this bail application, because I filed immediately after arrest, I was more on section 40 something, so your lordship rejected my. Then this bail application was filed. This was the second bail application. And in this bail application, they had taken that plea of formal apprehension and actual custody.
Violation of fundamental right.
Fundamental right. Fundamental right of beyond 24 hours. Similar type of facts, not very identical, but here also.
So your submission is that that plea can be taken at
any point of time, because at the end of the day, that is violation of Part 3 of the Constitution of India.
Okay.
This is my, that here also, my lord, it was in the second bail application, that plea was taken, and your lordship gave credence to this plea, and eventually he was bailed out. Okay. Stage the subject to the punishment of the magistrate may authorize his detention other than unless an order is passed by the initial. There is one paragraph my junior is trying, he is hinting that I should read to your lordship because it is an order passed by your lordship itself. Para 16, it says, however, it is your lordship's order. The name of it is BA 1662/2025, BA 1662/2025, order dated 2/6/25, June 2nd, 25. Para 16, as section 187 of the BNSS, which is in perimeter with 167, categorically states that.
Where are you reading?
Your lordship, is this Bittu Kumar versus State of Assam? Bittu Kumar. So,
you have not given a copy.
Bittu Kumar, BA 1662.
Yes. Para?
Para 16.
Yes, please read.
However, as 187 of the BNSS categorically states that subject to condition of bail, the magistrate may authorize his detention either in judicial or in police custody. Unless such an order is passed, the initial arrest of the petitioner beyond the period of 24 hours from the time of arrest would become illegal. And your lordship has even observed in one of those cases that your lordship has depreciated the practice of putting a separate time in the arrest memo. Perhaps your lordship will remember.
Yes, okay.
And even your lordship has gone up to observing that if the accused is in hospital and could not be produced because of some medical reason, then it is incumbent of the magistrate either to visit the hospital personally or his production should be done through video conferencing. I remember, my lord, that is one judgment passed by your lord. Yes. Now this is, and the third one is my lord, prolonged incarceration, because my lord will kindly appreciate they are neither. My lord, before going to prolong, I'll add one line, my lord. My lord, I have seen one tendency of the DRI or the NCB. This tendency is not there with the polices. They quote an astronomical monetary figure of the contrabands. My lord, in few cases I have seen, they do it just to persuade the mind of the court. My lord, I'm putting a question to myself. Which market has a MRP for drugs? Can there be an MRP, metrological, that act does not apply to contrabands? Drugs is based on availability and geography. Ganja may be cheap in Tripura, may be very expensive in Jammu and Kashmir. These are fictitious figures. My lord will not believe the 739 grams of heroin is projected in this case to worth 5 crore 17 lakhs. These are figures, fictitious figure. They cannot produce any authentic document. From where they're getting these rates? From where, my lord? There is no legal rate for contrabands.
No, there will be no legal rate for
Absolutely.
contrabands,
Absolutely.
which is circulated in black market.
Absolutely. It is based on, I have gone through some UN papers, my lord. It is based on availability and geography. Nobody can come up with these figures. They are just doing it. Suppose, my lord, ganja, you get raw ganja in Tripura. Now, somebody is caught in Agartala, and you are calculating the rate in terms of availability in Coimbatore. That is what they do. They take the maximum value and from wherever. Well, these, according to their statement, 10,000 rupees this person gets for driving a car from Aizawl, from Manipur to Gauhati. 10,000 rupees. This is the petitioner number one. He is carrying goods of 5 crore. Just anything they will say, we'll have to believe it. What is the basis of it? Have some material basis. Show from where you are coming up with these figures. 739 kg, 5 crores. People are dying, my lord, in Manipur, my lord. There are no, there are hardly any means of livelihood.
Okay.
And prolonged incarceration, my lord, that I'll
We
not
will
take much time.
continue at 2.
My lord.
Anybody on the item 46?
For reasons mentioned in the judgment, this court finds no infirmity in the impugn order and this criminal petition is accordingly dismissed.
Item 11.
Yes, my lord. Now I'm on the last limb of my argument. There is on prolonged incarceration. Now, my lord, as far as just one thing I skipped, my lord, while I was making submission, the fact that I was produced at 1 o'clock was brought to the notice of the NCB as well as this court by means of filing an additional affidavit. That affidavit was filed way back in the month of May. The NCB has not denied it.
Countered.
Countered it. So, my lord, if we go by the rules of pleading, a fact which is not denied amounts to admission.
Okay. Yes.
Yes. Now, my lord, as far as the prolonged incarceration is concerned, my lord, I'll not bother this court much, my lord, on this point, because your lordship has umpteen number of times have gone through those Ravi Prakash and those things. And recently also, my lord, Supreme Court in one of the cases where more than 1 year was taken to be, to be an inordinate delay, was constituted to be an inordinate delay more than 1 year. Yes, my lord, I am cognizant, my lord, this delay is also dependent on the quantity of this recovered, quantity of contraband recovered. So, my lord, in my case also, the quantity recovered is 250 gram is the commercial quantity. It is only another 200 some grams more. It's not that much huge a quantity.
200 gram heroin is
739 grams. 739 gram would be 250. Yes, 300 something gram.
of heroin is huge quantity. It is.
My lord, we have seen cases in terms of kilograms, my lord.
Heroin.
So, heroin, my lord, because as far as the fundamental rights are concerned, my lord, that is immaterial.
And otherwise also you are behind the bars for only 1 year, 4 months.
1 year, 4
And
months.
in most
none
of the cases where apex court granted bail, apart from a few exceptions may be there, but in most of the cases, not before 1 year, 6 months.
Now it is true, my lord, because then in that case, my lord, because I had other grounds, my lord. 1 year, 4 months, I have one judgment, my lord, Justice Sudhanshu Dhulia. This is 23 kgs
Ganja.
of ganjas. 1 year.
Ganja, 23 kg ganja and 700 gram heroin is a huge difference.
Now, my lord, it is how the court perceives that, my lord. But as far as, my lord, the other two grounds are concerned, in those two grounds, my lord, probably this will, because, my lord, even 24 kilograms of methamphetamine, when it was seen that there is a violation, was granted bail, my lord. And out of 12 witnesses,
In this case, how much was the delay?
delay was 1 year, 4 months, 24 days.
Okay, okay.
And my lord, as far as 1 year, 6 months is concerned, my lord will just appreciate in 1 year, this is how many months? 4 months, no? No, in my case, 1 year, 4 months, 29 days. Yes, tomorrow it will be 1 year, 5 months. And within next 1 month, if we take 6 months as a benchmark, within this 1 month, in whatever little I understand, my lord, probably the trial will not
No,
even.
the law, as per me, my understanding is that if there is a prolonged incarceration, you will get bail. But what is the period of prolonged incarceration depends upon facts and circumstances of the case. 1 year, 6 months is not a benchmark. Though courts are granting bail for on the ground of prolonged incarceration, in some of the cases where 1 year, 6 months have been lapsed, but it is to be determined considering the facts and circumstances of individual case as to what would be the period which may be regarded as prolonged incarceration.
Quantity. Now, this is also 22C, my lord. It is by your lordship, my lord. 6,000 yaba tablets. 6,000 yaba tablets. This is order dated 7/1/2026 this year. And the total delay was 1 year, 6 months, and 7 days. So, my lord, if 1 year, which is why, my lord, I am saying subject to correction, my lord, this is a case, your lordship will find the quantity at para number 3 and the delay.
Yes, yaba tablet contains methamphetamine. What is the commercial quantity that benchmark? It depends on each case. You cannot say that.
Methamphetamine also, my lord, 6,000 tablet. I mean, it's huge because the commercial quantity of methamphetamine would be.
Still, you have not completed 1 year.
No,
what is your submission?
Yes, my lord. My submission is this, my lord. If at all, my lord, for this quantity, the 300 more grams, my lord, if with this quantity, 1 year, 6 months is, suppose, my lord, is taken, it's 1 year, 5 months, your lordship may constitute it because tomorrow it will be 6 months, 5 months. Within next 1 month, out of 12 witnesses, not even a single witness has been examined so far. Even if we presume that the trial will proceed at my lord, at the speed of a light, even then I don't think more than 1 or 2 witnesses maximum. And the next date fixed, my lord, by the time my friend completes his submission, I'll give the. So, my lord, inordinate delay is also one of the ground because my first 2 grounds still remains that violation of in those cases, my lord, perhaps your lordship will not take into consideration this the quantity, my lord, because if those 2 grounds, if your lordship is of the view that those 2 grounds really exist in favor of the petitioner, in that case, my lord, that quantity is, and already I have submitted, my lord, those.
No, if there is a breach of fundamental right, then quantity is immaterial.
Absolutely.
But quantity is material to ascertain
the ground of
how much should be regarded as prolonged incarceration.
Yes. So, my lord, to whatever little I understand, my lord, had my case been solely based on prolonged incarceration, then in that case, my lord, perhaps
Okay.
the quantity, but my case is primarily based on the two other limb of submissions, my lord. So, my lord, this is what, my lord, I'll submit for this, as far as this bail application is concerned, my lord. Charges has been framed way back, my lord, and most of these DRI officials now they are posted in different parts of the country, and they are also not turning up, my lord. So that's my submission, subject to what the counsel for the DRI submits, my lord.
Yes, Mr. You are Mr. Bora. Bora.
Your Lordship, first and foremost, Your Lordship, as the learned senior actually pointed out, that I have not actually filed any kind of objection with regards to their affidavit, but we have filed an objection to the bail application. Now, in the bail application, Your Lordship, they have mentioned that the DRI officials intercepted the vehicle of the petitioners at around 9 a.m. That is their own statement in the bail application.
Yes.
And now they have filed an additional affidavit to the effect that no, it was 1 a.m. They're contradicting their own statement.
Okay.
And they have not given any kind of proof as supporting evidence as such to say that no, I had been arrested, I have been detained, not arrested, Your Lordship. Sorry, I'm using the wrong word. I've been detained at 1 a.m. To that effect, Your Lordship, there is no such averment or to that any evidence supporting the averment in the bail application. Because in the bail application, they have stated themselves that they were intercepted at 9 a.m. I am taking Your Lordship to paragraph number page 4, paragraph number 3. Thereafter, Your Lordship, if I have to take Your Lordship on this aspect itself with regards to pleading, the ground which my learned senior has taken with regards to non-compliance of section 36 is nowhere to be found in the bail application, nor in the additional affidavit. So I as such cannot counter it. This section 36 is a new form of line of argument that has been taken because there is no averment as such. So I cannot counter it by way of filing. Now I have to file an additional affidavit, additional counter objection to whatever my learned senior has stated. Because this is nowhere stated in a bail application, not even a whisper, not even one single line. As to section 36.
Additional affidavits?
No. The additional affidavit copy which I have, Your Lordship, it doesn't mention anything with regards to non-compliance of section 36.
You have not taken it?
Should I reply to this one?
Yes.
My lord, section 36 ground was not taken in the additional affidavit. That is the position. That is the correct position. Now, my lord, the issue is this. I am not taking a ground out of my knowledge. I am taking this ground which is ex facie available in the record. My lord, pleading in a criminal case is immaterial. The court will always go by the evidence. Even if I plead I am innocent by means of some pleadings, it is the evidence which will...
Okay. No, their only concern is
Yes, that
they
it
could
is-
have countered it by filing.
Yes. Even
A
Supreme
counter.
Court
They have
has
not-
very recently held on this particular aspect. There has to be averment in the pleading itself. It is not that the pleading is not necessary.
Okay, you
Be it a
complete
criminal-
your submission.
be it a claim-
I'll give my
proceeding.
counter. Let him complete his admission.
Supreme Court has said very recently that even in criminal proceedings also, pleadings to that effect is necessary. Because the department cannot effectively counter that particular argument. Even though it's a point of law. Now coming to that, even just for the sake of arguing, with regards to non-compliance of section 36.
Yes.
Now, section 36 says one witness who is a respectable member of that locality. Now, the main purpose of the agency here concerned, the DRI, is nabbing the person who are involved in nefarious activities with regards to NDPS materials. Now, the main purpose of that investigating officer, the arresting officer, is not to find out any respectable member of the society who carries a particular certificate to the effect that he is a
No.
respectable member of the society.
You have to make me understand one thing. When law says that for effecting arrest, you have to follow this procedure.
Yes.
You cannot ignore the law saying that my main purpose is to nab him by any means. If you are to arrest, you are to detain somebody and curtail his liberty, then you have to follow the law.
Yes.
And law is very clear.
Law is very clear. And to that effect, your lordship may kindly go to page number 63, the arrest memo itself, wherein not one, two independent witnesses have given a signature.
You address on the point raised by him.
Yes.
He says that though there are two witnesses in the arrest memo,
Yes.
but they are not of the locality from where the arrest has been made,
So,
as required under law. 36B says that the witnesses should be of that locality.
yes.
And he says that his submission, if you remember,
Yes.
that this is a mandatory provision.
The language is
Shall, as well as it has been clarified in earlier in DK Basu in a perimeteria
provision, with regard to
provisions.
section 41. Now, with regards to this particular aspect, your lordship, I had a talk with the investigating officer in that respect, and he said that there is no such criteria as to who is a respectable member of the society.
No, okay, everybody may be regarded.
He has got a certain amount of respect, even
Yes.
if not the respect.
Yes, yes.
So, to that respect,
That
he is
respectable part goes.
that respect.
So we can treat everyone as respectable.
Respect.
If we take it liberally.
Yes.
But locality,
Locality, your lordship, he was there present at that particular point of time. That with those witnesses, those were witnesses who were present at that particular point of time, at the time of detaining those persons, and they had stated that I am a resident of that particular locality. So, on the basis of that statement given by the independent witness itself,
where is that statement?
your lordship, that will come later on when they are examined, your lordship, when a trial happens, your lordship.
No.
But
On what basis you are making these submissions?
Your lordship, that they are, because I cannot say anything because that averment has not been there in the own petition as such. I cannot.
But the submission which you are making,
Yes.
it must have a basis.
Your lordship,
In case diary somewhere some entry must have been made
your lordship,
that
it is on the same
that
line.
the arresting authority inquired, are you from that locality? He
Yes.
said that he's from you. You are submitting that he said that he's from that locality.
Yes, this is as per, because this particular submission is not based on any averment. So I could not actually counter it. I cannot counter it on by way of an objection, your lordship. Your lordship may kindly understand my predicament also. Because just like my senior had actually argued on this particular aspect, the section 36 has not been complied with, your lordship. So I cannot counter it because
Then you don't counter it, but you don't say something which does not have, because when you make a submission before court, it must have some basis. Otherwise, you will be in trouble.
your lordship, the thing is,
If you don't have instruction, you may remain silent. You may say that I will take instruction, but you cannot make submission which are not true before the court.
Your lordship, this is based on telephonic instruction that I have actually received. And on the basis of the telephonic instruction that I have received, your lordship, that the person, the independent witness said that he was a member of he was a resident of that locality.
There should be an endorsement to that effect in the case diary.
Lordship, the arrest memo itself, otherwise he would not have been taken as an independent witness, your lordship. The arrest memo itself bears his signature.
Suppose you take anybody's signature, how court will find out whether he is from a local?
For argument's sake, your lordship, we do not have a bag of witnesses that, as my learned senior actually stated in his arguments, that the prosecuting agency have got a bag of witnesses, but we do not carry a bag of witnesses. Your lordship.
How court will distinguish? How court will find out
His
that
signature is there in the arrest memo itself, your lordship.
you can take anybody's signature in arrest memo in the police station.
Also, he is listed as a witness.
Therefore, he has taken this plea that in charge sheet a different address has been mentioned.
Even the Supreme Court has said that even in the absence of any independent witness also, if the prosecuting agency's case is based on strong evidentiary value, then this section 36 may not be complied with, Your Lordship.
Yes, show it to me.
Your Lordship, if Your Lordship gives me some time, then I'll produce the judgment also to that effect. But for the sake of argument only, because here this is just a mere academic exercise, because there is no pleading to that effect, so that I can actually counter it.
No, why I am putting these queries? Because his entire case is based on this plea.
Yes. Yes,
That if this court comes to a finding that there was a violation of section 36 and consequently the violation is of Article 21, then he'll get bail.
Listen, but
So
for
this-
to that effect, Your Lordship, I'm sorry to interject, Your Lordship, at this moment, but to that effect, there has to be averment that there has been a violation of Article
Yes,
21,
that
Your Lordship.
submission you have made.
That averment is not there, Your Lordship, so that I could actually validly counter it by way of an objection.
Okay.
That is not there. Secondly, Your Lordship, coming to with this arrest, issue of arrest and detention. The distinction which with my learned senior tried to actually draw, that the person concerned, the accused, were actually arrested way back at 1 AM. For the sake of argument, I'm going by the argument that he was detained or arrested at 1 AM. Even then also, if I may place one judgment on a similar lines, Your Lordship, just 1 month back, Your Lordship, on the same issue.
Can you give the bail number?
Bail application number 980 of 2026. So my learned senior only appears in that.
I know which one. Your Lordship's order, no?
Yes, on the same issue, same ground taken. If I may take Your Lordship to para number 21 of Your Lordship's order.
Very good.
Yes.
It is pertinent to mention herein that this is for the third time the petitioners approached the court seeking bail in connection with above noted case. It appears on earlier occasion, when the petitioner approached this court, they also took the plea of non-compliance of mandate. In fact, in this petition, the whole bail application was based on non-compliance of section 48. But they have not stressed on that. They are totally on a different trajectory, which is not based on any kind of averment. So, nonetheless, Your Lordship, here, while rejecting the plea in paragraph 25 of the order, court also stated the reasons for doing so. It was photocopy of the envelopes, and I will not trouble Your Lordship with this particular aspect with regards to non-compliance of section 48, since this had not been actually agitated by my learned senior in this particular aspect. Now, coming to paragraph 22 with regards to violation of Article 22 and the delay part. As regards the second contention of violation of provision of Article 22 of the Constitution of India is concerned, it appears that though the petitioners were arrested on 13/12/2024, that is more than 1 year, 5 months ago, however, it is for the first time in the instant bail application, they have raised the plea that the time of arrest mentioned in the arrest memo, that is 20 hours on 13/12/2025, has been wrongly mentioned therein, and that the actual time of the arrest is 12:45 AM. This court has no second opinion as regards the legal proposition that in the arrest memo, the date and time of actual apprehension of an accused has to be mentioned. The meaning of arrest is to take a person in custody. It means that law has taken control of such person and he is in the physical hold of an arresting authority with coercive power. The practice of showing incorrect time in the arrest memo can never be encouraged for whatsoever reason, as it tends to defeat the constitutional protection guaranteed to an arrested person. However, as to what was the actual time of putting the person under lawful restraint so that he may be deemed to be in custody is a question of fact, and same has to be determined after considering the facts and circumstances of a particular case. In the instant case, the complaint petition filed by the DRI in paragraph 7 of the same has been categorically stated by the DRI that the petitioner was summoned to accompany them to DRI office. Same case, here also. They were not arrested, they were summoned to accompany them to the DRI office. It is also stated herein that the petitioners were requested to hand over the mobile phones, which they did voluntarily. Nothing is there to indicate that any coercion was used on the petitioners at any point of time. Neither the same has been alleged by the petitioners in the same case, present case also. It also reveals that thereafter, the petitioners consented to be searched in presence of a gazetted officer, and according as per the consent of the petitioners, the search was so made. However, nothing was found from the personal search. Therefore, on disclosure made by the driver of the truck, namely so-and-so, who was seated in the front seat of the Toyota Fortuner vehicle, the contraband seized in his case was recovered concealed in secret chambers located between driver's cabin. Here also secret chambers were there. and that took time. That we have stated in our bail objection also. Thereafter, the procedures of seizing the recovered contraband were conducted. It appears from record that there is no indication that during the entire procedure of the search and recovery of the contraband, any restraint was put on the petitioners by implying any force. It appears that they voluntarily cooperated with the DRI officials in the entire procedure for search and seizure. It is only after that it was ascertained that huge quantity of heroin was recovered. The petitioners were arrested at 8 p.m. and arrest memo was prepared showing the time and date of the arrest therein. Had the time of arrest been wrongly mentioned in the arrest memo, then for the last 1 year and 5 months, the petitioners got several opportunities to point out that the time of arrest stated in the memo of appeal is wrongly mentioned and they were arrested prior to the time mentioned in the arrest memo. The petitioners never pleaded that they did not voluntarily cooperate during the procedure of search and seizure and that the entire procedure of search and seizure was conducted after arresting them. The arrest memo categorically mentions the date and time of arrest at 8 p.m. on 13/12/2024. If date and time of arrest is wrongly shown in the arrest memo, the petitioners ought to have raised the objection at the earliest point of time. However, they failed to do so and raised the safety only when they are before this court for the third occasion, here second occasion, which raises doubt about veracity of the plea.
No, in this case, his plea is that after intercepting you at 9 p.m., 9 a.m., you were taken to DRI office at 10 a.m.
Your Lordship, the main allegation that they have actually stated that they have been arrested since 9 a.m. For the sake of argument,
No, 10
they
a.m.
are saying that 9 a.m. or 1 a.m. they have been detained. Now, since 1 a.m., if suppose there's a huge difference between detention and arrest, Your Lordship, because if I may place one more judgment of the Honorable Odisha High Court on the same issue very recently, it relates to NDPS matter NCB. Herein, in this judgment, if I may take Your Lordship to paragraph number 10 onwards, Your Lordship. And in fact, I won't trouble Your Lordship with paragraph number 10. I'll take Your Lordship straight away to the last 3 lines of paragraph number 11. A person, last 3 lines, Your Lordship, from the bottom.
Yes.
A person may be detained or his liberty is temporarily disrupted in course of search and seizure, but it cannot be treated as detention alike arrest. At any time of such search, the
No,
presence
but
of
Apex Court has given a contrary view earlier, way back in
80s.
80s.
These are par incuriam judgment, my lord.
in fact, these are not per incuriam, Your Lordship. In fact, it is, if I have to take Your Lordship to the whole judgment, in fact, it has actually discussed all the judgments also with regards to detention and arrest. And also what fell from Your Lordship on a very similar set of circumstances. That person concerned, in that case also, they were detained because the main purpose of any detention is to find out whether any kind of illegal narcotic substances has been actually.
No, but if you are detained,
Yes.
then you have to follow 22.
Yes.
Article 22.
But at the same time, this detention as such, it won't amount to arrest, Your Lordship. Because here,
Apex Court says that it amounts to arrest.
Your Lordship, that is where I beg to differ. Because here also, they were detained only with respect to, because if suppose they were simply let go, then they would have absconded there and then.
Therefore, that is the arrest.
That's why, Your Lordship, that is not arrest, Your Lordship. That Your Lordship has observed here.
Where?
In this judgment of Mariappa, Your Lordship, which Your Lordship authored, bail application 980, which are.
No, in this Marippa's case, they were issued summons.
Yes.
And in pursuant to summons, that is the case of the
They were
DRI.
same circumstances, Your Lordship. They were not issued summons. Their vehicle was also intercepted. In fact, they were intercepted prior to, the present case petitioners. They were not summoned, Your Lordship. There, in that case, the vehicle was Toyota Fortuner vehicle. Here is a Mahindra Bolero.
No, I have to go through it, but the averments made in the complaint of that case It was about that you voluntarily went to DRI office.
Here also, your lordship, here we have stated, in fact, in our objection also. This particular statement as such, it's there also in the charge sheet, your lordship will find it. As well as
Where is in the charge sheet? Show
in the
me.
bail objection, your lordship.
No, not in the bail objection, in the final complaint, show
In
me.
the lordship, there in the record, TCR only I can actually point out, your lordship. It is there. Because the same statement has been made in the bail objection also.
Give the TCR. Okay, page 31.
Page 31 of the bail petition, miss.
Bail petition,
31.
31.
Yeah.
On one side, you are saying that DRI official took them to office. And others, on the other hand, you are saying that they were summoned.
Your lordship,
If somebody is summoned,
Ah,
you need not to take them.
Yeah,
They
it's-
have to
it's-
come. Otherwise, these constitutional protection would have no meaning at all, if you can.
Because here, if I may just place paragraph, if your lordship perusses to paragraph number 4 onwards of the final complaint. Here, they were also brought under summons notices, your lordship. Along with the intercepted vehicle. They were not taken, they did not took as such.
Okay. Anything else?
Your lordship, I place reliance on those two judgments only, your lordship. Apart from that, of course, with regards to first plea that my senior has taken, my submission is only with regards to that issue that there is no averment, so that I can actually answer.
my lord. That submission which I made regarding section 36, that submission is made from the record, number one. Number two, my lord, he has submitted, my lord, that he has taken already telephonic instruction was taken. So he was put to notice. He has taken telephonic instruction and during the break hour, and the telephonic instruction is date on the factual part, not on the law. And the telephonic instruction is this, that they are not supposed to, their main purpose is to nab. They are not, they are not to collect witnesses. If I have understood him correctly, my lord, their purpose is to nab, not to collect witnesses. And further, he has submitted on instruction that they have put their signature. And on the basis of this, it has to be construed that they are from the locality, whereas their own document at page number 63, that is the list of witnesses which they have annexed, the address is somewhere else. And if on that, if they require any, my lord, if they could have, my lord, taken time for making, for obtaining instruction, my lord, because he has already obtained telephonic instruction. So therefore, my lord, the plea that they were not put to notice regarding this, though that is not required, my lord, because in my humble submission, my lord, something which emanates from the record of a criminal case, the constitutional court can always look into that more so when it relates to violation of somebody's basic fundamental right. A constitutional court can always, suo moto can go through. My lord, that DK Bosu case, my lord, just my lord, one line I'll add. How that case originated. No petition was filed in a DK Bosu case. In a DK Bosu case, a gentleman who was working as a NGO man, he wrote a letter to the Chief Justice based on some newspaper cutting.
No.
Yes.
Maybe, but while arriving at a conclusion as to whether fundamental rights were breached or not, courts have to go into the questions of facts. And for facts, you have to aver those facts.
My lord, if, because I don't want that, because of that averment, only because that averment is not there, that there is a violation of section 36. In that event, my lord, because I have already made my submission, let an opportunity given, I'll file a 1-page affidavit, my lord, let them take 1 week time, file counter to that. And on the returnable date, I'll not make any submission, let this be, otherwise also this is be before your lordship only because it's the second bail application. If, because for one, that averment, if at all that is an impediment to my client's right to bail, then let there be, my lord, otherwise also this bail is lingering for at least 4 or 5 months. So I will make by tomorrow 10 o'clock, 10:30, I will file an affidavit. Let them take time with a copy to my friend. Let that issue be decided. That would be the best course, my lord.
Heard Mr. M. Vishwas, learned counsel for the petitioner. Also heard Mr. P. Bora. D. Bora, learned standing counsel, DRI.
Senior standing counsel.
Learned senior standing counsel, DRI. Though this bail application was substantially heard, however, during the course of hearing, learned counsel for the petitioner had submitted that the petitioner may be allowed some time to file an additional affidavit to bring on record certain facts which are relevant for consideration of the instant bail application. Learned senior standing counsel submits that in that event, the DRI may be granted time to respond to the said.
I have strong objection with regards to this submission because it's a bail application. It's not, they cannot improve upon the case by filing additional affidavit after additional affidavit. That is not sufficient.
Though learned counsel for learned standing counsel for for DRI has strongly objected to the prayer. However, considering the submission of learned counsel for the petitioner that the facts sought to be brought before the notice of this court relates to breach of the fundamental rights of the present petitioner. Hence, the prayer is allowed. Let this matter be listed.
In the meantime, I will file by tomorrow, your lordship. No, I will file by tomorrow. That your lordship may fix it on 30. I'll file by tomorrow and before
30 years.
Oh, that is 30 I will say.
Can be on 6th of August. Not 6th of August, lordship. 31st. 31st of July, lordship.
Let it be on 31st of July. Before that, they may file, and as far as I am concerned, I'll file tomorrow morning.
31st of July. Let this matter be listed again on 31st of July.
On which date, my lord, both the parties will exchange whatever pleadings are required. So again on 31st, if time is short, my lord, let it be. If at all, if there is an observation that by that date, both the parties, whatever pleadings has to be filed, they will file it.
That is.
No, we don't know what we will be
What he
filing.
will say actually.
We'll give a shorter date. No, let it be on 31st of July.
Let it be on 31st.
31st of
July.
Let it.
Lord, while drafting, my lord, a lot of things keeps the notice of the advocate, but while making the final preparation, things comes up. This actually, I'm not strongly, my lord, opposing his here because this skipped my notice. I'm to blame myself. And this is,
But this may be a very
Yes.
major thing.
yes, it is only day before yesterday when I was making my final notes, my lord, then this fact came into my eyes.
Yes.
May please, your lordship. My lord, the appeal filed by the claimant for enhancement, your lordship.
Heard Mr.
And Devnath.
N. Devnath, learned counsel for the appellant. This appeal under section 173 of BNSS 2023 has been preferred by the appellant, impugning the judgment and award dated 26/3/2026 passed by the Motor Accident Claims Tribunal number 3, Kamrup Metro, in MEC case number 394/2019. The appellant is basically aggrieved with the quantum of compensation awarded to them, appellants awarded to them. I have gone through the grounds stated in the memo of appeal and considered the submissions made by learned counsel for the appellant. Stop. This appeal is admitted. Let the records of MEC case number 394/2019 be called for from the concerned Motor Accident Claims Tribunal registry to take steps for requisitioning the records. Let the notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26th August.
Oblige, your lordship.
Exhibit 7.
That's an injury case, and for operation of gallbladder, some bills were produced. And that is why Lordship Tribunal has awarded 10 lakhs. There is no disability certificate. We'll deposit 50%.
Heard Mr. S.K. Goswami, learned counsel for the affluent insurance company. This appeal under section 173 of Motor Vehicles Act 1988 has been filed by the appellant, namely Oriental Insurance Company Limited, impugning the judgment and award dated 19/12/2025 passed by the Motor Accident Claims Tribunal number 1, Kamrup Metro, in MEC case number 243/2021, whereby the appellant was directed to pay a compensation amount of rupees 10,09,347 to the claimant respondent with interest thereon. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by learned counsel for the appellant. This appeal is admitted. Let the records of MEC case number 243/2021 be called for from the concerned tribunal, the registry to take steps for requisitioning the records. Let also notice be issued to the respondents. The appellant shall take steps for issuance of notice upon the respondents by speed post as well as by usual mode within 7 days from the date of this order, returnable on 26 August next IA. This interlocutory application has been filed by the applicant insurance company in connection with MEC appeal number 368/2026, praying for stay of execution of the impugned judgment and award during the pendency of the connected MAC appeal. Sublearned counsel for the insurance company submits that the insurance company is agreeable to deposit 50% of the awarded amount as a condition for grant of stay of execution of the impugned judgment and award. Considering the submissions made by the learned counsel for the applicant, the notice to the respondent is waived and this interlocutory application is allowed. The execution of impugned judgment and award dated 19/12/2025 passed by the MACT Motor Accident Claims Tribunal number 1 Kamrup Metro, Gauhati in MAC case number 243/2021 shall remain stayed during the pendency of the connected MAC appeal number 368/2026, subject to deposit of 50% of the awarded amount by the applicant insurance company before the registry of this court within a period of 6 weeks from the date of this order. This interlocutory application is accordingly disposed of.
Obliged.
May I please be Lordship? Lordship, this memorandum of appeal is for enhancement of compensation.
Heard Mr. A. Agarwal, learned counsel for the appellant. This appeal under section 173 of Motor Vehicles Act 1988 has been preferred by the appellant, namely Bhuban Bora, impugning the judgment and award dated 33/2026 passed by the Motor Accident Claims Tribunal number 2 Kamrup Metro, Gauhati in MSC case number 1309/2019, whereby the appellant was awarded a compensation amount of rupees 6,67,631 along with any interest at the rate of 7.5% per annum. The appellant is basically aggrieved with the quantum of compensation awarded to him. I have gone through the grounds stated in the memo of appeal and have considered the submissions made by the learned counsel for the appellant. This appeal is admitted. Issue notice to the respondents and call for the records of the MAC case number 1309/2019 from the concerned tribunal. Stop. The registry shall take steps for requisitioning the aforesaid records. The appellant shall take steps for issuance of notice to the respondents by speed post as well as by usual mode within 7 days from the date of this order, returned in the law 28th August.
Same enhancement of compensation, Lordship.
Same order. The quantum award to belek থাকিব এইটো চাই ল'ব.
Interest amount is same, Lordship. 7.5%.
Remaining will remain same except the awarded amount.
Obliged, Lordship. Highly.
Because just a moment. Yes.
My lord, we are in this case, my lord. The claimants, my lord, has preferred this appeal, my lord, against the judgment. Judgment was passed by learned tribunal awarding at rupees 17,20,000. And out of this total amount, my lord, 50% has been deducted on the ground of contributory negligence on the part of the deceased motorcyclist. What happened, my lord? Motorcycle was driven by the deceased and there was a accident and the star bus accident took place head-on collision. Charge sheet submitted, FIR was lost by the claimant side. And after due investigation of the matter, the police submitted charge sheet against the star bus. And on the basis of the charge sheet, my lord, and my lord, FIR, my lord, the finding of the learned tribunal found that a 50% should be deducted. Accordingly, 50% deducted on contributory negligence. My submission before your lordship, the claimant side examined one PW and none was examined by the insurance side. But regarding contributory negligence, my lord, it should be proved there is no plea in their WS. There is nothing examined as regard the contributory negligence by the insurance company. And my lord, on the presumption of the learned tribunal, 50% deducted. The Supreme Court says, my lord, I have some
No,
citation.
before you go to Supreme Court,
my-
what was the reasoning of the
Yes,
tribunal?
yes,
Read that portion.
my lord.
Page number.
Page number 11 portion, my lord. 11 portion. Page number, your lordship, appeal memo 17, my lord. 17, 16, my lord. 16. 16, my lord. Paragraph, my lord.
Not number.
Decision and reason thereof, issue number 1 and 2. May I read, my lord? This is the here in this paragraph findings, my lord, noted, my lord.
Okay, read, please.
May I read,
read.
my lord? The claimant number 1 has examined herself as a sole witness in support of his case filed by the claimant, and she also filed various documents and medical certificate to establish the case in favor of them. The opposite party respondents, however, have not adduced any formal evidence in the case. From the evidence of witness and materials brought on record, particularly the accident information report, Form 54, Exhibit 2, coupled with the certified copy of the FIR dated so and so Exhibit 1, PM report of the deceased Abdul Mannan account, Exhibit 3, and all other materials available in the case diary of Tarabari PS case number so and so under section so and so, which includes the copies of the FIR, exact copy of Tarabari PS GDNT number so and so dated so and so, along with charge sheet number so and so dated so and so. Seizure list, report of MBI sketch map, it becomes under clear evidence that the LS motor vehicular accident had taken place on 2/4/2018 at about 10 a.m. at Senga, Borbeta Para under Tarabari PS in the district of Borbeta, Assam, with the involvement of 2 motor vehicles bearing registration number so and so, that is Star Bus, and number AS so and so motorcycle. Myself was motorcycle, my lord, causing accidental death of Abdul Mannan Akand, and in respect of which the police case got registered at the Tarabari PS as Tarabari PS case number so and so under section 7. The claimant have attributed cause of accident to the rash and negligent manner of the driving of the offending Star Bus, but its driver, opposite party number 2, claimant has failed to establish its allegation about rash and negligent driving of the offending bus by adducing evidence of any creditable eyewitness. It is clearly a case of head-on collision, and report of MBI clearly suggests that the front side of the motorcycle, that is visor, headlight, handle, front indicator, and front shock absorber, and the left frontal side of the bus, left hand side bumper, LCI's headlight, so and so, was found damaged. Due to the accident, the LS accident, the accident had taken place on the left side of the road. It is however not clear at what speed and manner the bus was proceeding at the relevant time and what exact occasion and the alleged accident. There seems to be contributing negligence both on the driver of the coordinating vehicles. Now, since it is not clear as to the manner in which the alleged accident had actually taken place, both the vehicle are held equally responsible for causing mere presumption, my lord. Mere presumption, not exactly tribunal is saying on the part of the deceased. Say, claimant shall entitle 50%. My lord, this is the finding of the tribunal. Now, my question, my lord, your lordship kindly see. In deciding in a MSC case, my lord, only, my lord, FIR and charge sheet is the vital documents. Charge sheet says, my lord, since, my lord, motorbike, scooty, motorcycle is smaller than the bus. Bus is big vehicle, my lord. Motorcycle is small vehicular, my lord. My lord, Supreme Court says, my lord, my lord, charge sheet and FIR is the vital evidence for deciding a MSC case, my lord. My lord, since, my lord, there is no eye evidence, there is no evidence adduced by the insurance side or claimant side, my lord, charge sheet is apparent. Charge sheet is very clear against the bus, where from the learned tribunal gate, the contributing negligence on the part of the deceased, my lord, that's why 50% has been deducted. It is, my lord, from their observation, it is presumed, my lord. The police, after the accident, police visited the spot.
In the written statement, whether insurance company took the.
Yes, my lord. My lord, I am going to the, my lord. My lord, your lordship is very much aware. Supreme Court says only plea is not sufficient to establish in respect of contributing negligence. That should be proved by causal evidence, my lord. My lord, their evidence, my lord. Just I'm pointing out my one line, my lord. This is the certificate going, my lord. I am reading, my lord. Para number 5. In this present case, the accident occurred due to involvement of vehicles and the accident occurred due to negligent manner of the driver of the driving of the driver of both vehicles. Hence, the opposite party contribute negligence should be decided. This is the plea, my lord. Whether it is a plea, yes, my lord, plea taken that has not been examined by them. Supreme Court says plea is not sufficient. Taking plea is not sufficient. That should be proved. It is clear established law, my lord. My lord, I have some citation I am giving, my lord. Judgment I am giving, my lord. My lord, this is the, my lord, finding of the tribunal. Presumption. Now, your lordship kindly see charge sheet. That charge sheet was filed on after the accident, immediately after the accident. That charge sheet has not been challenged by the insurance company. Whether this charge sheet is wrong or right, their duty, there has to be some objection over the charge sheet. Nothing says before the court below, my lord, where charge sheet was submitted by police. Whether any objection was made at the relevant point of time? No. Now, they have not produced anything before tribunal. They has not examined anything. And only on presumption by the learned tribunal, my lord, our 50% may not be deducted, my lord. My humble submission before your lordship. Now, your lordship kindly see some judgment, my lord. My lord, very important judgment, my lord. My lord, plea is not sufficient. That judgment I have also given here. My lord, this judgment, my lord, first judgment, my lord, 2012, this is TSC, Kerala High Court, my lord. Just I am beginning by this judgment, my lord. para number, my lord, page number 1817, below para, my lord, in this context, my lord. In this context.
Yes.
Have you got some?
Yes, yes.
In this context, we feel that it appropriate to refer the practice adopted many tribunal in the state where the crime has been registered in the state of the accident and investigation of calculated in the filing the charge sheet by the police. Such charge sheet is filed and the same is manner to sufficient to establish the negligence on the part of the incidency. Practice has not been received formal judicial approval and hence some materials inside in the oral evidence in support of the negligence invariably. This comes at loss of judicial time and heavily overwork. Tribunal is its time on unnecessary oral evidence of negligence. We should not want to tribunal to be prisoners of the include the police. If the tribunal finds there is suspicion, it can insist the better evidence. General rules can be safely be accepted. The production of police of the prima facie sufficient evidence of negligence for the purpose of a claim under section 166 of MB Act, and it is a system need to the regular direct the diet of the district or joint concern prima facie. The charge sheet filed by the police officer after due in negligence of the government accepted as evidence on negligence against he is not so much clear, my lord. Clear on the point. Evidence of such prima facie. Next para, my lord, your lordship kindly see next para. We do not intend to say the collusive charge sheet accepted whenever we the fact the given in the state tribunal feels that the police charge sheet does not justify their judicial conscience, the tribunal can record that the charge sheet cannot be accepted. And the my lord, this is the my lord finding, my lord. If tribunal feels no, it is charge sheet cannot be accepted, then the court should take, my lord, further evidence, my lord, on the negligence, my lord. My lord, it is very clear from this judgment, my lord. Once charge sheet is filed by the police, that has to be, if that has not been challenged, that has not been challenged by either of the parties, that to be accepted, my lord. Now, your lordship kindly see the next judgment, Supreme Court judgment 2009 3 HCC 285.
Yes.
Pleading, regarding pleading, my lord. Yes, my lord. In their WS, they have taken a plea, contributed as regard contributed negligence. That plea should be proved. Otherwise, it will not be accepted, my lord. My lord, I'm just reading headline, my lord. Headline says, my lord, in absence of any pleading or evidence to substantiate appellate stand, rejection of plea, High Court was justified. Plea has not been examined, my lord, or proved, my lord. That cannot be accepted, my lord.
Okay.
The relevant para, my lord, here in this judgment, my lord, 5, 7, and 8, my lord. Just I am pointing out, my lord. My lord, another judgment, my lord. Another judgment, Soyad Sadiq Iqbal, Soyad Sadiq and others reported in 2014 HCC, my lord. 14 HCC, my lord. In Soyod Sadiq case, my lord, paragraph 29, my lord.
Yes.
Paragraph 29, my lord, regarding contributory negligence, my lord. May I read, my lord?
Okay, that plea without proof.
Yes, my lord. Exactly, my lord.
Okay.
Without proof. My lord, a contributory negligence, as and when we say about contributory negligence, that should be proved, my lord. Nobody sees the accident. Nobody sees. That should be proved. This has to be, my lord, a vital point, my lord, charge sheet. Police, after investigation, submitted, he is the best person, my lord. Like, normally, my lord, that is a big bus. And I am, my lord, scooty, my lord, a motorcycle, my lord. And after due investigation, charge is submitted against the bus. Now, before tribunal, my lord, either insurance company or my lord claimant side, nothing has been examined, my lord, as regard contributing. From where, my lord, learned tribunal observe on presumption, my lord?
No,
Tribunal cannot.
tribunal was of the view
My lord.
that since the front side of the motorcycle has been damaged, therefore there was a
My
head-on
lord,
collision.
exactly, my lord.
That is the only reason.
My lord, my submission before, suppose, my lord, accident took place, head-on collision. Motorcycle fell on the Paka road. My lord, broken, my lord, by any, my lord, any side may be broken, my lord. My lord, that is not a point, my lord, I think, my lord. Subject to correction, my lord. My lord, law, what says law, my lord? Law says, my lord, yes, contributory negligence should be proved. Only plea is not sufficient. That should be proved. And Sadiq, my lord, Soyed Sadiq case, my lord, says, my lord, just time point my headline, my lord. Therefore, we incline that we hold the contribution on the part of the claimant side in the accident not proved by the respondent by adducing evidence, and therefore the finding of the tribunal regarding contributory negligence which has been upheld by the High Court is set aside. Here in this case, my lord, contributory negligence has not been proved by appellant side. Set aside. Another judgment, my lord, our High Court's judgment, my lord. Our High Court judgment 2012 for GLT, my lord.
Yes.
Here in paragraph, my lord, paragraph 14 and 15, my lord. May I read, my lord?
Yes.
14, paragraph 14, my lord. Paragraph 14 says, my lord, this is our High Court judgment, my lord, 2012 for GLT, para 14. However, while conducting the inquiry into the claim under section 166 of the MB Act, tribunal is not accepted to search for proof or evidence beyond reasonable doubt. Rather, it is a preponderance of the probability what the tools is for assessment of the evidence. The tribunal can arrive at the finding on the prima facie materials as such first information report, the report to presume existence of certain fact, the in absence of evidence which might devise such presumption. In view of this finding, the based on return by the learned motor accident on contributing accident is interfered and set aside. Basis thing, my lord, prima facie, my lord, to decide the MACT case, my lord, FIR and charge sheet, my lord. If tribunal found that those charge sheet, those FIR is falsely lost the FIR, he can verify, my lord, taking further more evidence. Assuming, my lord, tribunal suspect the charge sheet, tribunal ample power to examine more evidence, my lord, on this regard. Nothing has been examined. And para paragraph 15 says, my lord, it is apparent that the respondent one did not adduce any evidence to substantiate their plea that the accident occurred for contributing negligence. The learned tribunal ought to have held that since the insurance company which raised plea of contributing negligence failed to discharge their burden of proof, the finding should favor the contention of the claimant. Very clear, my lord. Very clear, my lord. Just I am pointing out, my lord, main point, my lord. Elaborate judgment, very nicely elaborately, my lord. Every judgment, my lord. And now your lordship kindly say 2010 to GLT. Paragraph 9, my lord. Paragraph 9, my lord. May I read, my lord?
Yes.
The learned tribunal has completely lost sight of importance of pleadings. The settled law that the party cannot adduce evidence in absence of pleadings in the suit or civil nature, and also related provisions of the Code of Civil Procedure, the Apex Court in Bangalore Metropolitan Transport, so reported in 2009, 3 SCC, and held that in absence of any pleading or evidence to substantiate the stand, there was no scope for accepting the plea that the negligence act of the deceased himself and resulted in the accident, and there was no negligent act on the part of the driver and bus. In the case, the plea the appellant before High Court as well as Apex Court was held that the negligence on the part of the deceased himself, as he was an intoxicated state by consumption of alcohol, as the consequence of which embraced himself and fell without involvement of the bus, but they fell the suffered injury and sustained to the same. But these facts were not pleaded by the appellant in the pleading, as such the Apex Court as well as High Court, in absence of pleading and evidence to substantiate those pleading, did not accept the plea and the appellant the negligent act of the deceased. Very clear, madam. Has to be proved, madam.
Okay.
Has to be proved, madam.
Yes. Yes, Mr. Bhatta.
Lordship, in this case, no eyewitness was examined.
Yes.
Even the charge sheet was also not exhibited by them. Lordship, the court has all the case diary, and on the basis of the case diary, the court passed the judgment. Lordship, kindly see the finding of the judgment. The report of the MJ clearly suggests that the front side of the motorcycle headlight, handle, front indicator, and front shock absorber, and left frontal side of the bus, left hand side headlight, left hand side front shock, left hand side indicator found damage due to the alleged accident. The accident had taken place on the left side of the road. That means the disease came in the wrong side.
Which left side means?
The bus was in the left side, Lordship. It was in case of,
No, disease may be on the left side.
no, this is in the left side. The damage of the bus was in the left side, on the right side. If they come from the right way, then it could have the right side.
No, my query is when the observation is that
Lordship, kindly see.
the accident
See,
occurred on left side of the road.
left side of the road.
Left side, if you are going towards south, left side will be different. If you are going towards north,
Bus was in the left side. Lordship.
sides always, if you move, side will change.
That is why right side of the bus was damaged, not on the left side. Left frontal side of the bus. The accident had taken place on the left side of the road. It is, however, not clear on what speed and the manner the bus was proceeding at the relevant time and what exactly occasioned the alleged accident. there seems to be contribution of the both rider of the driver of the following vehicle. Probably in the lordship case diary, the sketch space was there in the.
No, but
work record, was
nothing
there.
has been indicated in the,
Lordship.
nothing has been indicated in the judgment.
The report of MBI clearly suggests that front side of motorcycle, headlight, handle front, indicator, and front shock absorber, and left frontal side of the bus, left side bumper, left side bumper, left hand side headlight, left hand side front shock, left hand side indicator.
Yes, what it indicates.
What indicated if the bus was, let's say, in the middle position, then it could have the damage of the bus in the right side.
How?
Because always the driver in the wheel of the right side, let's say, not in the left side.
But the court has only assumed. Read next line. Since it is not clear as to what manner accident actually.
That's clear.
When you are saying that it is not clear, then again, how you can say that it is contributory negligence? You read next line. Tribunals.
They could have adduced lordship eyewitness, who eyewitness was there lordship.
Or you could have adduced evidence for contributory negligence. Because the appeal is not.
The allegation of rash and negligence was pleaded by them. They have
That has been proved. Therefore,
they did not prove. They did not prove. That is why court called our case diary lordship. On the basis of the case diary lordship, the judgment was passed.
okay, what else is your submission?
That's it.
What else is your submission? Anything else? Anything else?
The tribunal has rightly considered all things on the basis of the case diary and rightly passed the order. The disease had also contributed in the accident, so it was a portion, let's say, regarding that contributing negligence.
Heard Mr. A. Manna, the learned counsel for the appellant. Also heard Mr. K.K. Bhatta, the learned counsel for the respondent number. Respondent number
Yes, number 3.
3/insurance company. This appeal under section 173 of the Motor Vehicles Act, 1988 has been preferred by the appellants / claimants, impugning the judgment and award dated 15/6/2019 passed by the Motor Accident Claims Tribunal, Borbita in MSC case number 124/2018, whereby the respondent number 3 insurance company was directed to pay a compensation amount of rupees 17,20,000, not 17 lakh, directed to pay an amount of rupees 8,60,000 along with an interest at the rate of 9% per annum to the present appellants. Stop. The appellants are basically agreed with the quantum of compensation awarded to them due to deduction of 50% from the computed compensation on account of contributory negligence. Stop. The facts relevant for consideration of the instant appeal, in brief, are that on 2/4/2018, the husband slash father of the present appellants, namely late Abdul Mannan Akan, was proceeding towards Borpeta from Chenga on his motorcycle bearing registration number AS15 E9367. Stop. When he reached Senga Borbita Para, one bus within bracket Tata Star bus bearing registration number AS01FC 4588, being driven in a rash and negligent manner, coming from the opposite direction, hit the motorcycle from the front side. As a result of the aforesaid accident, the husband slash father of the present appellants sustained severe injuries on his head and other parts of body. Stop. Though the injured was immediately rushed to Senga BPHC, however, doctors informed that he was brought dead to the hospital. Stop. After the accident, one police case, that is Tarabari PS case number 87/18 under section 279/304A of the Indian Penal Code, was also registered at Tarabari Police Station. Stop. Next paragraph. Thereafter, the present appellants, being the wife slash daughters of the deceased Abdul Mannan Akan, filed an application under section 166 of the Motor Vehicles Act, claiming compensation on account of death of their husband slash father in the aforesaid motor vehicular accident. The said application was registered as MAC case number 124/2018 before the Motor Accident Claims Tribunal, Barpeta. The owner of the offending vehicle did not contest the claim case filed by the present appellants, and the inquiry proceeded ex parte against him. Stop. However, the present respondent number 3 within bracket the insurance company as well as the driver of the offending vehicle filed written statement denying fault on their part. Where are the issues? Original record. The on the basis of pleadings of both the parties, the Motor Accident Claims Tribunal, Borpeta, formulated following issues. Quote issues from page 32 from the LCR. The claimants examined the claimant number 1 as the sole witness in support of their claim and exhibited certain documents, including the accident information report, the postmortem examination report, where is the indication that case diary was called for?
Here is, apart from, my lord, our exhibited document.
How many exhibit
My
documents?
lord, 4 exhibit, my lord. 4 exhibit. Exhibit 1 is a, my lord, FIR. Exhibit 2.
FIR.
Exhibit 2 is the search sheet, my lord.
It's not exhibited.
Or search sheet not exhibited. Yes, search sheet exhibited, not exhibit 4. It is that.
Exhibit reports have set the record.
My lord, exhibit 4 is the search sheet, my lord.
Lordship, it was cross-marked, Lordship. The LCR, the evidence, Lordship, it was cross-marked regarding the exhibit 4.
Our evidence, my lord, we have exhibited. And exhibit 1 is the FIR, exhibit 2 is the 54 form, exhibit 3 with PM report. Three exhibit,
Only 3 exhibits.
three exhibit, my lord.
Charge sheet was not accepted.
क्या क्या लिखा? It also appears that the tribunal had also gone through the case diary of Tarabari PS case number 87/18, as well as documents sent along with the which includes the charge sheet and other documents like Caesar list, sketch map, etc. Ultimately, by the judgment which has been impugned in this appeal, the tribunal computed the damages sustained by the appellants on account of death of their husband/father to the tune of rupees 17,20,000. Stop. However, the tribunal came to the finding that there was contributory negligence on the part of the deceased, and as such, the claimants were found to be entitled to 50% of the total compensation computed by the tribunal. That is, which comes to is
8,60,000.
8,60,000.
60,000.
Stop, along with an interest at the rate of
9%.
9% per annum. Stop. Mr. A. Manaf, the learned counsel for the claimants/appellants, has submitted that the tribunal has committed an error in deducting 50% of the total computed compensation amount on account of contributory negligence by the deceased. He submits that the tribunal erred in coming to the conclusion that there was a contributory negligence on the part of the deceased without there being any evidence on record to that effect from the insurance company or from the driver of the offending vehicle. He submits that the law in this regard has been settled by a catena of judgment of the apex court as well as by this court that mere pleading of contributory negligence in the written statement is not sufficient to come to the conclusion that there was a contributory negligence on the part of the deceased / claimant. The plea of contributory negligence has to be proved by adducing cogent evidence in that regard by the respondents, which is not done in this case. Learned counsel for the appellant submits that the tribunal took a contradictory view in the impugned judgment, wherein it observed that it is not clear as to the manner in which the alleged accident had actually occurred. However, at the same time, it held both the vehicles involved in the accident equally responsible. Even though there was no evidence to that effect on record. He therefore submits that the impugned judgment is required, impugned judgment and award is required to be modified to the extent that the deduction of 50% of the total computed compensation amount by the tribunal on account of alleged contributory negligence of the deceased should be set aside, and the appellants may be awarded the entire computed compensation amount of rupees 17 lakhs 17 lakhs how much?
17 lakhs 20,000.
17 lakh 20,000. Stop. In support of his submission, he has cited a following. In support of his submission, the learned counsel for the appellants has cited following rulings. New India Assurance Company Limited versus Fazani Ammal, reported in 2012, 1 TAC 816. Number 2, Bangalore Metropolitan Transport Corporation versus Padma and others, reported in 2009 3 SCC. (2009) 3 SCC. 285. Number 3, Syed Sadiq and others versus Divisional Manager, United India Insurance Company Limited, reported in 2014 to SCC 735. Number 4, Godavari Devi Sharma versus and others versus United India Insurance Company Limited, reported in 2012 for GLT 516. Number 5, Baba Lakshmi Dev Burma versus and others versus Nupur Dev and others, reported in 2010 to GLT 93. Stop. Next para. On the other hand, Mr. K.K. Bhattor, the learned counsel for the respondent insurance company, has submitted that the tribunal has rightly arrived at a conclusion that there was a contributory negligence on the part of the deceased within bracket husband slash deceased. What was the name?
Deceased my lord Abdul Mannan Akand.
Abdul Mannan
Akand.
Akan. He submits that the claimants, by adducing the witness of sole, adducing the evidence of sole witness, that is, claimant number 1, have failed to establish the fact of rash and negligent driving by the driver of the offending vehicle. He submits that the present appellants slash claimants have also failed to educe charge sheet which was submitted in Tarabari PS case number 87/18 against the driver of the offending Star bus within bracket Tata. He submits that it is only the tribunal which, after going through the case diary of the Tarabari PS case number 87/18, came to the finding that since the damage of frontal side of the bus on left hand side as well as damage of front side of the motorcycle within bracket visor, headlight, handle, front indicator, front shock observer, indicates that there was a head-on collision between both the vehicles. And since the accident took place on the left side of the road, there seems to be contribution of both the driver of the colliding vehicles. And therefore he submits that the tribunal was correct in coming to the stop. वो उसका पहले वाला लाइन stop. he submits that while arriving at the said conclusion, apart from the documents exhibited by the PW1, the tribunal also considered the extract copy of Tarabari PS GD entry number 18/18 dated 2/4/2018, as well as charge sheet number 100/18 dated 31/8/18, Caesar list, reports of MVI and sketch map. Hence, he submits that the conclusion arrived at by the tribunal, holding that there was a contributory negligence on the part of driver of the motorcycle, within bracket the deceased, is not without any basis, and same needs no interference by this court in exercise of its appellate jurisdiction. Anything else, Mr. Bhatto? Anything else? He therefore submits that this appeal is liable to be dismissed. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also gone through the rulings cited by learned counsel for the appellant in support of learned counsel for both sides in support of their respective submissions. Stop. Reserved. ... I'm reserving the judgment. Heard so and so. Hearing concluded. Judgment reserved.
I love this.
May I please, Lord? This is also, I want some time, Lordship, to file application, Lordship, under order 41, rule 27.
You are the appellant.
Yes, Lordship.
40 and
Order 41, rule 27.
item number given.
43.
Old case, my lord, date case.
Only 1 week time.
Heard
Since
Miss-
long back it is pending, my lord.
heard Ms. D. Burman, learned counsel for the appellant. Also heard Mr. H. Das, learned you are for insurance company.
No, I am insurance company, Lordship. He is the
Claimant, my
claimant and Lordship, owner and vice.
Learned counsel for the respondent now / claimant, as well as Mr. What is your name? What is your name? Heard Mr. T. Uddin appearing for Mr. S. Ahmed, learned counsel for respondent number 2 and 3. Learned counsel for the appellant in appeal number 306/2023. Ms. D. Burman has submitted that the appellant intends to file an application under order 41 rule 27 of the Code of Civil Procedure for allowing the appellant to bring additional evidence on record at this stage and prays for some time for doing so. The prayer is allowed. Let this matter be listed after
That may be
after 1 week.
Any date?
Date did you? Second. 13, no, second week of August. First or second week of August. Sixth. Let this matter be listed on 6th of August.
And item 44, it is cross appeal filed by me.
We are passing a common order.
Common authority. I love.
45.
Yes, mention question.
I pledge, my lord.
It is ready for hearing,
Yes, my lord, it is listed for hearing.
but you mentioned for to get it listed in orders column.
Yes, on that payment.
Then how it got listed in hearing column?
I don't know, because since the service is complete, my lord, and the
No,
case
but
is.
in the mention memo,
Yes, my lord. Yes,
you
mentioned.
have to
I
mention.
I have written as orders, my lord.
Okay, today both of you are ready?
Yes, ma'am.
Okay, start.
This is a appeal by the owner, my lord. Owner of the vehicle, my lord. My lord, there is a order of pay and recovery, my lord.
Okay.
I'm challenging that part, my lord. My lord, this case proceeded ex parte against this appellant, my lord. The reason, my lord, if lordship may come to page 19, my lord.
Yes.
But this is the order sheet of the tribunal, my lord.
Yes.
My lord, page 19, the order dated 19/5/23.
Putul. Itu Agor case. Yes.
Order dated 19/5/2023. May I read, my lord?
Yes.
Claimant and opposite party number 1. My lord, opposite party number 1 is the appellant here, my lord. Claimant and opposite party number 1 are represented by learned advocate. Seen and peruse the case record and petition number so and so filed by the claimant and so and so filed by OP number 1. The claimant did not file form number 54. Hence, the instant case is kept in abeyance till arrival of form number 54. The case will be put up after submitting form number 54 by the claimant side, my lord. Then, my lord, lordship may come turn to the next page, my lord.
Yes.
Order dated 28/6/2023. Case is put up today on the strength of petition number so and so, since the petition number so and so filed by the claimant, wherein stated that this tribunal had order dated 19/5/23. The claim petition was kept in abeyance with a direction that the claim petition shall be put up on the date when claimant shall furnish the form 54 before the tribunal. That by filing this petition along with a copy of form 54, the claimant prays to accept the same and pass necessary order. Heard the learned counsel for the claimant. Peruse the form 54. Considering the same, the prayer is allowed and the instant case is hereby restored. Fixed 18/7/23 for WS. Then, my lord, may come to next page, my lord.
Yes.
Page 21. Order dated 1/9/23. Claimant is represented. Opposite party number 2 has submitted WS. Let the copy be furnished to other side. Opposite party number 1 is absent. Notice has returned after service. Hence, case will proceed ex parte against the opposite party number 1. Fix so and so for draft issues.
Yes.
So, my lord, what happened initially? The form 54 was not submitted. Then, my lord, it was submitted on 28/6/23. But after submission, my lord, neither the council was informed, nor, my lord, any notice issued to the opposite party number 1, my lord. So
no, this notice is earlier notice.
Earlier notice issued, the opposite party number 1 appeared through counsel, my lord. My lord, the page 19 order, my lord. Since the case was kept in abeyance, my lord, due to non-submission of the Form 54, my lord. Order
Okay,
dated
when the case was put up on the strength of
Form 54 on a petition and along with the Form 54, my lord. When the case was revived, it was not informed either to the counsel or to the my lord, to the party, my lord. No notice issued, nothing, my lord. I have even checked the record, there is nothing, my lord. So that's why this case proceeded ex parte against this, my lord, appellant.
so you could have
Yes,
Right,
that
for-
is their order 9 rule 13. But my lord, the main reason, my lord, the court has directed to pay in recovery on the ground that there is the appellant was driving the vehicle under the influence of alcohol, my lord. If lordship may kind, I mean directly taking to the said finding, my lord, page 42, my lord. That is the relevant portion of the judgment, my lord. Page 42.
Yes.
Paragraph 19.
Yes.
May I read, my lord?
Yes.
It appears that there is no dispute that the offending Maruti vehicle was duly insured with the opposite party number 2. The OP number 2, HDFC Ergo General Insurance Company Limited, has not denied it. The OP number 1, Arup Kumar Barua, being the owner and driver of the said offending Maruti Swift vehicle, has not appeared in this case, and hence the case against him proceeded ex parte by submitting written argument. My lordship may kindly note that, my lord, this is written argument, not written statement, my lord. By submitting written argument, learned counsel for the OP number 2 insurance company has stated that at the time of the alleged accident, the owner cum driver of the offending vehicle, that is OP number 1, Arup Kumar Barua, was driving the vehicle under drunken condition. He further submitted that the aforesaid fact.
Now, whether any evidence was adduced?
No. By the insurance company, no evidence. Even in their WS, this plea is not there, ma'am. He further submitted that the aforesaid fact is supported by the FIR, Ijahar, forwarding report of accused and the extract copy of Gujaran OPGD, entry number so-and-so, dated so-and-so. Therefore, it is submitted that driver, vehicle under the influence of liquor, is in violation of section 152A of the MV Act. Hence, the OP number 1, Arup Kumar Barua, has violated the policy condition as well as the statutory law. I have perused the entire materials available with the court's case record. It is found that the driver, Arup Kumar Barua, OP number 1, was driving his Maruti Swift vehicle bearing registration number so-and-so under the influence of alcohol, which is in violation of policy condition. Accordingly, Arup Kumar Barua, OP number, is held liable to pay the compensation amount to the claimant. However, it
No,
is to
from where? I peruse the entire material. It is found, from where it was found?
My lord,
Read last line, last line in page, last 3 line.
page 42.
Page 42.
Last 3, I have perused the entire materials available with the case record.
Thereafter,
It is found that the driver, Arup Kumar Barua, OP number 1, was driving his Maruti.
from where it was found, apart from the written argument, is
One
there
day-
anywhere else also?
My lord, what happened, my lord, even the insurance company has filed one petition before the tribunal to call for the GR case record as well as, my lord, the investigating officer. That was rejected. There is no evidence from the insurance company or any of the respondents, my lord.
So when the tribunal is saying that it was found from record, it was found that OP number 1 was driving his vehicle under the influence of alcohol.
Yes, ma'am.
From where,
Nothing is there, my lord.
apart from the written argument of the,
Nothing is there. Even in the WS, only, my lord, one line in the FIR. The FIR is exhibited, my lord, by the claimant. Only one line, my lord.
what is that?
My lord, in the FIR only one line, Gadi number AS 06Z6200 খনৰ চালক শ্ৰী অৰূপ বৰুৱা পুৰাময় অৱস্থাত গাড়ী চলাইছিল বুলি জানিব পৰা গৈছে. That is not his the informant. জানিব পৰা গৈছে মানে. Then this FIR is, my lord, exhibit 2, my lord.
Okay.
And my lord, this FIR was lodged by one Rajan Borgohain, my lord. He was not examined, my lord. And page 28, my lord.
Yes.
My lord, this is a petition filed by insurance company before the tribunal.
Yes.
My lord, if lordship may take up the see the prayer, my lord, it is therefore prayed that your honor may be pleased to allow the opposite party number 2 to examine IO of GR case number so and so as DW, and also a direction may be given to IO to produce toxicology report of the driver of vehicle number so and so for the ends of justice. This petition was filed by insurance company, and lordship may find the order at page 29. Next page, my lord.
Okay. Yes.
And my lord, page 29 is the order passed in that petition, my lord. Order dated, my lord,
Repair
2/7/20.
was rejected.
Rejected, my lord.
Okay.
They have not challenged that, my lord. And my lord, the only exhibit is the FIR, which says, my lord, the person come to know, but that person was also not examined, my lord. And my lord, the exhibits and the evidences, page 44, that is the annexure of the judgment, my lord.
Yes.
Page 44, my lord, last page.
Yes.
My lord, the witness of the defense, none. And my lord, column number 4, my lord, witness exhibits of the defense, none, my lord. And my lord, in the exhibit 2 is the only certified copy of the Ejahar, my lord. And that too,
Only in that document there was a mention that it was that the informant came to know that you are under
influence of the alcohol,
liquor.
but he was also not examined. And he also come to know. He had not seen or he had
So it
not
was here
come to know.
hearsay for him also.
Yes, my lord. And in the WS of the insurance, my lord, there is nothing, no claim, my lord. I have annexed the WS. That is at page 22, my lord.
Okay.
No plea that he was under the influence of alcohol. So nothing was in the record, my lord. The court only on the basis of written argument, my lord. The court has says that since it is stated in the written argument, and only on that basis, my lord, the court come to finding that the appellant was driving under the influence of liquor, my lord. And due to that, my lord, since there is a breach of policy, so pay and recovery is guaranteed, my lord. So that is.
Yes, Mr. Kolita.
My lord, my basically point is that, my lord, that this is a question of fact whether he was under the influence of alcohol on that day or not, my lord. Because, my lord, the learned tribunal, while conducting an inquiry, has found that he was under the influence of alcohol.
From where it
From the FIR, because there is an allegation of intoxication by the informant.
Yes, that was only allegation.
Allegation, my lord.
Now, this is an allegation, my lord. Now, my lord, my humble submission is that since it is a fact within the special knowledge of the party concerned, so it was his burden to disprove it. Now, he did not participate in the proceeding, my lord. Neither he took part in the proceeding, nor he filed any application to get the case started again by filing petition under order 9 rule 13. Straightway he filed the appeal because this is a question of fact, my lord.
No, therefore evidence is required. Fact has to be proved by evidence.
Yes, ma'am.
It is a question of fact. How tribunal came to a conclusion that this is a
Because there is an allegation of intoxication on the part of the informant.
no, only allegation, whether only allegation is sufficient to
That
come
is-
to a finding
my
that that
submission-
allegation is
My
true.
submission is that, my lord, that this is a fact, the special knowledge fact of the person alleged
No,
it.
my query is why and how tribunal came to this conclusion that he was in the under the influence of alcohol. There was an allegation that he might be. No, he has came to know that the opposite party number one is in under the influence of alcohol. But first informant was not examined.
Learned members finding, my lord, lordship will find at page 42, as my learned friend has already pointed out, that
From the records.
from the record.
Yes.
FIR,
From which record?
he further submitted that the aforesaid fact is supported by FIR Ejahar, forwarding report of the accused, an extract copy of Gulijan OP GD entry number 250 254 dated 16 16/01/23.
What is forwarding in the forwarding report?
Because he is the accused person in this case, my lord, the present appellant in the main criminal case, my lord.
But insurance company did not adduce any evidence.
My lord, to my understanding, my lord, because the section 50, my lord, the newly inserted provision, my lord, the this is a statutory defense provision, my lord, section 50, 150, subsection 2, my lord. Subsection 2, clause A. A condition, I'll read that, my lord. A condition excluding driving by a named person or by any person who is not duly licensed or by any person who has been disqualified for holding or obtaining a driving license during the period of disqualification. This aspect was earlier in the earlier act also, my lord. Now, latest insertion is that driving under the influence of alcohol or drugs as laid down in section 185. This is the newly inserted provision, my lord, in the act. So basically,
Where are you reading?
My lord, the new MV Act, my lord.
New MV Act provision?
Provision, my lord, section 150.
Yes.
Subsection 2.
Section 152, yes.
Clause A.
Small a.
Then Roman 3, my lord. So Roman 2.
No, these are the grounds, defenses which you can take.
Yes, you can take.
But you have not taken this ground in your written statement. 150 says that these grounds may be statutorily taken by the.
My lord, we didn't have the opportunity to take this defense because we had to rebut the allegation in the written, the claim petition. The claim petition also did not disclose, of course, that he was under intoxication.
Because we could only reply against the claim petition only. We could have replied by filing the statement, my lord. Otherwise, we had no scope to rebut this. I mean, take this defense. This is of course my lord, statutory provision, my lord, that section 152, 150, subsection 2, driving under the influence of alcohol. But there is an allegation of alcohol consumption, my lord. My lord, in fact, my lord, the appellant has not contested the case. There is no pleading on their part. If they want to disprove this fact, my lord, they could have filed petition under section order 9, rule 13, my lord.
No, suppose they have not done so. They can also file appeal against the ex parte judgment,
Of course, my lord.
which they have done.
They can file one. Now, since this is a question of fact, and to my understanding, my lord, this is a question of fact, and this is a case of special knowledge against the person alleged to. When I've been alleged that I was under the influence of alcohol, that I need to disprove it.
Who has alleged?
The informant has alleged against the appellant.
In the criminal case.
In the affair, my lord.
In the criminal case. But
In the criminal
in the inquiry before tribunal, who has alleged?
But
There is no.
those records were before the learned member, my lord. The criminal papers, my lord, not police papers.
Okay. Anything else?
This is my submission, my lord, because my lord, while conducting the inquiry, my lord, the tribunal has found this aspect, my lord.
We heard Mr. A.K. Gupta, the learned counsel for the appellant. Also heard Mr. T. Kolita, the learned counsel for the respondent insurance company. This appeal under section, you may take your seat. I will dictate I will dictate some portion. This appeal under section 173 of the Motor Vehicles Act 1988 has been filed by the appellant / owner of the offending vehicle, owner or driver?
Owner driver, both men.
Owner / driver of the offending vehicle, impugning the judgment and award dated 21/8/2024, passed by the learned additional member, passed by the Motor Accident Claims Tribunal number 2, Tinsukia, in MAC case number 20/2023, whereby the respondent number 4 insurance company, namely HDFC Argo General Insurance Company Limited, was directed to pay a compensation amount of rupees 17,71,073 only, with an interest at the rate of, what was the interest? Interest at the rate of dash to the respondent / claimants, and thereafter were given liberty to recover the said amount from the owner / driver of the offending vehicle, that is the present appellant. The what was the percentage?
8%.
8%. The present appellant is aggrieved with the judgment to the extent that the insurance company was directed to recover the compensation payable by it to the claimants from the present appellant. Stop. The facts relevant for consideration of the instant MAC appeal, in brief, are that on 16/1/2023 at about 3:50 p.m., one swift car bearing registration number AS23Z6200, coming from Tinsukia side towards Guijan, knocked one auto rickshaw bearing registration number AS23BC9901, which was parked on the extreme left side of the road at Nalan Hi Hola Papasali. Stop. Due to the said accident, the auto rickshaw driver, namely Krishna Mili, sustained grievous injuries on his person and he died on the spot. After the said accident, one police case, namely Tinsukia PS case number 28/2023, was also registered under section 279/338/304A/427 of the Indian Penal Code. Against the driver of the offending vehicle, and later on charge sheet was also submitted in the said case. After the aforesaid accident, the wife and children of the deceased approached the Motor Accident Claims Tribunal additional member Tinsukia by filing an application under section 166 of the Motor Vehicles Act seeking compensation on account of death of their husband/father in the aforesaid motor vehicular accident. Stop. The said claim case was registered as MSC case number 20/2023 before the additional member Motor Accident Claims Tribunal, Tinsukia. The inquiry proceeded ex parte against the present appellant. However, the insurance company contested the claim by filing written statement. In the said inquiry, upon pleadings of the parties, the tribunal, Motor Accident Claims Tribunal, formulated following issues. Court issues from page number 35 of the memo of appeal. Thirty-five and 36 of the memo of appeal. Stop. In support of their claim, the claimant number 1 examined herself as CW1 and exhibited certain documents which were exhibited as Exhibit 1 to Exhibit 9. The क्या लिखा था? ठीक ठीक next paragraph. One Krishna Preme was also examined as CW2 or as a witness for the claimant side, as well as one Labenya Nagate was examined as CW3 for the claimant side. The insurance company did not adduce any evidence in their defense. Stop. Ultimately, by the judgment and award which has been impugned in this appeal, the claim petition was allowed and the compensation was awarded to the claimants in the manner as already has been described in the foregoing paragraph of this judgment. Stop. Mr. A.K. Gupta, the learned counsel for the appellant, has submitted that the present appellant is the owner and the driver of the offending vehicle. He submits that after filing of the MSC case number 20/2023 before the Motor Accident Claims Tribunal number 2, Tinsukia, when the matter was fixed before the said tribunal on 19/5/2023, both the claimants as well as the present appellant were represented by their respective counsel. However, on that day, since the Form 54 was not filed along with by the claimant, the said MSC case was kept in abeyance till arrival of MSC case number, till arrival of Form 54. In that case, he submits that thereafter, though the matter was again put up before the Motor Accident Claims Tribunal on 28/6/2023 on the basis of a application filed by the claimants before the tribunal, bringing on record the Form 54. However, since this date was not known to the present appellant, and since no notice was issued to the appellant after keeping the MSC case 2023 in abeyance on 19/5/2023. The appellant, being unaware about the putting up of MEC case before the tribunal on 28/6/2023, could not appear before the tribunal on that day. He submits that thereafter, on 1/9/2023, what is this notice returned after service?
Initial notice, ma'am.
1/9/2023, though the tribunal in its order passed on the said date mentioned that notice return issued to opposite party number 1 within bracket, that is the present appellant, have returned after service. However, it was the original notice issued in the aforesaid case, in pursuant to which the appellant had already appeared before the tribunal on 19/5/2023. He submits that after keeping the aforesaid case in abeyance by the tribunal, no fresh notice was issued to the present appellant in the aforesaid case, and therefore he was unaware about fixing of the case ex parte against him. Stop. Learned counsel for the appellant further submits that the Motor Accident Claims Tribunal has also erred in coming to the conclusion that there was a breach of policy condition on the part of the present appellant, as he was found to drive the offending vehicle on the date of alleged accident under the influence of liquor. He submits that apart from he submits that no evidence is there on record to indicate that the appellant was under the influence of liquor. He submits that the only material on record which indicates that the appellant might be under the influence of liquor is the written argument submitted by the counsel of the insurance company before the tribunal, as well as the first information FIR which was exhibited by the claimant side as Exhibit 2. He further submits that in the Exhibit 2, the informant has alleged that it has come to know that he has come to know that the appellant was driving the offending vehicle under the influence of liquor, which he submits that is in the nature of a hearsay evidence. He further submits that the informant of the first FIR, which has been exhibited as Exhibit 2, namely
Sri Brojen Borgohain.
Shri Brojen Borgohain, was not examined either by the claimant or by the insurance company to adduce evidence as regards allegations of the present appellant driving the offending vehicle under the influence of liquor. He further submits that no such plea was taken by the insurance company in its in the written statement filed by it in the said inquiry. As such, he submits that the tribunal has arrived at a finding regarding breach of policy condition without there being any admissible evidence on record. As such, he submits that the impugned judgment and award is liable to be set aside to the extent it directs the insurance company to recover the compensation payable by it from the present appellant. Anything else?
But the toxicology report and the IO prayer was rejected by the tribunal.
He further submits that though the insurance company had filed an application before the Motor Accident Claims Tribunal on 2/7/2024, praying for examination of the investigating officer of the GR case number 56/2023 as DW, and also to produce and also to issue a direction to the IO to produce the toxicology report of the driver of the offending vehicle before the tribunal, was rejected by the tribunal by its order dated 2/7/2024, and the said order of rejection was not put to challenge by the tribunal, by the insurance company. Hence, he submits that there is no evidence on record on the basis of which the tribunal could have arrived at a finding that the present appellant was under the influence of liquor when the alleged accident occurred, and as such there was a breach of the policy condition. He therefore submits that the ऊपर लिखा है कहीं the to the extent पढ़िए तो stop dot. On the other hand, Mr. T. Kolita, the learned counsel for the insurance company, submits that the tribunal, the motor accident tribunal, has rightly arrived at the conclusion that there was a breach of policy condition by the owner of the offending vehicle, inasmuch as after perusing the materials on record, which includes the FIR, forwarding report of the present appellant as an accused in the criminal case which was filed after the accident, as well as extract of the Guijan OP GD entry number 250/254 dated 16
Date is my lord somehow.
Godbar.
Somehow confusing. 1601 cannot be.
Dated continue. It came to conclusion that the present appellant was driving his Maruti Swift vehicle under the influence of alcohol on the date of alleged incident. He submits that the present appellant, he submits that the fact as to whether the petitioner was under the influence of liquor or not is a special knowledge which would be exclusively known to the present appellant only, and therefore he ought to have adduced evidence to counter this allegation which is leveled in the FIR in the connected criminal case. He submits that the anything else, one line. He also submits that when the inquiry proceeded ex parte against the present appellant, he could have filed an application for setting aside ex parte order, and later on he could have also filed an application for setting aside the ex parte decree. But same was not done by the present appellant. Hence, he submits that now the present appellant cannot take this plea in this appeal. Anything else?
My submission is that, my lord, the fact that he was under the influence of alcohol, that has not been denied by the appellant himself during the proceeding, my lord, because of the fact that the case proceeded ex parte against him. Now, again, my lord, section 106 of the Evidence Act, that could have been availed by the appellant if they had participated in the proceeding, my lord. Now, secondly, my lord, this is now the question of
one line, the line. He also, बाद में मिलाना पड़ेगा. He also submits that the allegation against the present appellant that he was under the influence of the liquor could have been denied by him by filing written statement. However, he failed to do so as the inquiry proceeded ex parte against him. He also submits that as the fact as to whether he had consumed liquor on the date of alleged incident or not was known exclusively to the present petitioner. It was he who had the burden of proving the said fact under section 106 of the Indian Evidence Act. Anything else?
secondly, my lord, the question of leading evidence and exhibiting the policy of insurance, in fact, arises on the part of the insurance company, my lord. That is a question of fact. But the thing is that, my lord, there is a statutory infraction on the part of the appellant also, because section 150, which I have pointed out, my lord, that aspect need not be proved before the learned member, my lord, because this is statute itself says that if the person is driving the vehicle under the influence of liquor.
No. But whether he is driving or not, this is a question of fact. This has to be proved.
Now, my lord,
whether there is an infraction of policy condition or not, insurance company has the burden to.
Two aspects, my lord. Violation of condition of the policy of insurance, as well as breach of the provision of the act. Now, here is breach of the provision of the act is clear, my lord.
No. What Act says? Act says that you can take this defense. 150, what it says? That he may not be entitled to. That the insurance company may be entitled to make made a party and defend the action on following grounds. You can defend.
Yes, my lord.
On following grounds. One of the ground is
driving under the influence of alcohol.
Yes.
This is clear. Now, for example, my lord, if the vehicle is plied by a person having no driving license at all.
Yes.
In that case also, my lord, the record shows that there was no license at all. Will there be any need for leading evidence? Because
no, but then you have to take plea.
Yes.
That he was having no driving license, then the burden shifts on the person to show that
Yes.
I have a driving
Yes,
license.
that judgment
But
of
here,
the my lordship knows that.
but here
Lamba, my
you
lord.
have not even taken plea that he was under influence of liquor.
Difficulty on our part in this case was that, my lord, the claim petition, we have got the claim petition, my lord. Against the claim petition only, we could file the written statement only. My lord. Problem is that.
No, why? When the vehicle was insured vehicle, even without filing claim, you are liable to compensate if the you have your own investigators.
Fine. Fine. That is there. That is there. But the record, my lord, says that it was only in the stage of evidence this aspect came out. The FIR was exhibited by the claimant side.
Yes.
Only then only the
FIR was exhibited by the
claimant
claimant side.
claimant side.
When you came to know that he was under influence of liquor, you could have taken this plea because this is a statutory plea. And you could have defended it by adducing evidence because claimant was not interested. He is interested in getting the compensation only.
Yes, sir.
Even there is no prayer for amendment also, man,
Yes.
during the trial.
Now, what is your further submission?
My submission is that this is a, my lord, apart from the establishing the fact that he was under the influence of alcohol, that is a question, my lord, not proved, my lord, by either of the parties, even by the applicant also, my lord.
Yes.
But the section 152A, there is a breach of the, breach of the provisions of the act, apart from the policy condition. Because, my lord, the learned member has also pointed out, hence, page number 42, my lord, hence, OP number 1, Paruk Kumar Barua has violated the policy condition as well as this statutory law.
Learned counsel for the respondent / insurance company also submits that in view of the provisions contained in section 150 within bracket 2 within bracket small a within bracket small a or b?
A, my lord, small, my lord.
A.
I'll check. My lord, it would be small a. Then, my lord, Roman 2, my lord.
Small a Roman 2.
Roman 2.
In as much as he was driving the offending vehicle under the influence of alcohol. Hence, he submits that the impugned judgment and order needs no interference by this court and the appeal should be dismissed. Stop. I have considered the submissions made by learned counsel for both sides and have gone through the materials available on record. I have also, you are citing any judgments?
My lord, only with since he is raising the plea of proof, my lord. So only one paragraph 14, that 100th section of Evidence Act, which says that the person who asserts he has to prove, my lord.
I have also gone through the rulings cited by learned counsel for both sides in support of their respective submission.
Para 14. ma'am.
Stop. Dot. Lord Mr. A.K. Gupta and T. Kalita. Hearing concluded, judgment reserved.
Obliged.
Highly obliged.